Malas.
It's called
Serial
convenience
number 5,
compilation.
Malas.
It's called convenience compilation.
Convenience, I'm just trying to check.
Murray, what is the page? PDF page?
Page 14, Malas.
Page 14.
PDF 14. Malas, prior to 2018, the elections took place in Shivsena in 2013. Then, Malas, they took place in 2018. Then they were due to take place in 2023. So this only reflects that the last elections took place
18.
in 2018. And a letter was written to the Election Commission saying organizational elections of Shivsena were conducted on 23rd January 2018 at Mumbai, and the information regarding the designations and names of the party office bearers sought
Ajay Kumar.
Election Commission of India is being endorsed herewith in format for your record. Along with this letter, the amendments to the Constitution were also enclosed. Anyway.
Yes.
Then, Malas, the office bearers' names your lordships will see. Shivsena Paksh Pramukh, Uddhav Thackeray. Shivsena leaders, deputy leaders, secretaries, and all that is set out. And Shivsena deputy leaders is Malas an extra one. And Malas. Now let's kindly see. Then the party whip.
What is meant by appointed the following persons as Shivsena leaders?
Some are elected, some are appointed.
But appointed the following members as Shivsena leaders to which Shivsena leaders appointed to where?
Which platform?
Which Rashtriya Karyakarani, Malas?
Or the National Executive?
Yes, yes.
Oh, I see. So this is a meeting of the National Executive held on 23rd January 2018.
Yes, yes.
At which these 4 persons were nominated as
Yes,
members of the
yes,
National
yes,
Executive.
Karyakarani. Elected are at page Malas 15. Your lordships will see that at page 15. PDF page 15.
Yes.
You see the elected ones, Malas. Name of office bearers elected. Your lordship sees that? 4th column from the left. So some are elected, some are nominated.
Right.
And see, if the last column you say list of names of leaders and deputy leaders appointed, co-opted by Shivsena Paksh Pramukh as also attached for your record, is also attached for your record. And that's an extra 2, Malas. So all this is informed, Malas, so there's no dispute on any of this. Of course, the Election Commission ultimately says, I don't have the Constitution. So I will not look at it, though it was annexed along with this very document, the amendments to the Constitution. Anyway, so then, Malas, kindly see June 21. chief minister. He was only president of the party on 25th November 2019. The reason why I'm inviting my Lord's attention to this document is, please have a look at it. It's to the Honorable Speaker, Legislative Assembly.
Yes.
That Shivsena's, ladyship has it?
715, did you say?
715, yes. Shivsena's newly elected MLAs meeting was convened in Shivsena Bhavan on Wednesday, 31st October. Meeting was chaired by Uddhav Thackeray, Shivsena Paksh Pramukh. All the newly elected MLAs of Shivsena party unanimously resolved that all the decisions of today's meeting be decided by Uddhav Thackeray and authorized Uddhav Thackeray to take all the decisions. Shri Eknath Shinde and Sunil Prabhu were appointed as group leader and chief whip of Shivsena Legislature Party in the Maharashtra Legislative Assembly. The resolution passed in this regard as follows. That it is resolved that elected MLAs meeting of Shivsena party, of the party, with Eknath Shinde is appointed as group leader. So he becomes the leader of the house, in a sense. And it is resolved that in the newly elected MLAs meeting of the Shivsena party, Sunil Prabhu is appointed as the chief whip. So the appointment is by the party.
This is information to the speaker.
That's right, information to the speaker. That's how it all happens, Malaj. When the leader of the house, Malaj, is, or the leader of the opposition, that's how the party conveys the...
This letter is addressed by Shri Uddhav Thackeray.
That's correct, that's correct. Just see.
Because the signature doesn't appear there, that's why I just asked.
Oh, I see.
Oh. Right. It may be right also, because it's addressed by those...
It doesn't matter, Malaj. It's an information of the decision of the party to appoint these two people as the leader, group leader, as well as the chief whip. Yes. It is chaired by the Uddhav Thackeray. And it says the party has appointed.
And
there's no doubt about that, Malaj. First para itself says so, Malaj.
No, it was in the meeting of the MLAs.
No. Shivsena's newly meeting was convened by Shivsena Bhavan. In the meeting was chaired by Uddhav Thackeray. All the newly elected members unanimously resolved that all decisions of today's meeting be decided by Uddhav Thackeray.
Okay. Now read resolution number 1.
Yes. It is resolved in the newly elected MLAs meeting.
MLAs meeting of so-and-so.
That is appointed. Resolution, yes, is appointed as the group leader of the Shivsena party. Resolved the newly elected MLA meeting of Shivsena party. Sunil Prabhu is appointed as the chief whip of the Shivsena.
So this was the resolution which was communicated was prima facie, subject to what you can say, correct? The elected MLAs meeting was convened.
Yes.
It was resolved like 1 and 2, which
Yes.
was intimated to the speaker.
Yes, but no one, the decision was of Uddhav Thackeray.
So, anyway.
The decision is of Uddhav Thackeray,
it
Malaj.
doesn't appear to be so, Mr.
It says so, Malaj, first paragraph. First and the second paragraph both. Second paragraph both say so, Malaj.
Second says that meeting was chaired, and third says elected MLAs unanimously resolved that all decisions of today's meeting be decided by Thackeray.
Uddhav Thackeray. So he is, and authorized by Uddhav Thackeray to take all the decisions in the meeting. The decision is of Uddhav Thackeray, Malaj.
But having said that, it also appears that the decision attains a certain degree of legitimacy because it is communicated by the MLAs to the speaker, it appears. It may be that, of course, as the unquestioned party leader at that time, he was to decide who would be the group leader and who would be the chief whip. But the communication to the speaker is signed by all the 56 MLAs, and they eventually resolve that who will be the group leader and the chief whip. It seems to be that.
As I showed to your lordships the law on the subject and the decision on the subject, it will be clear that it is only the party that appoints. No member of the
We
legislature.
understand that because your submission yesterday was that the appointment of the chief whip or the group leader is something which is never done by the
Never
MLA.
done by the-
It's always done by the party.
I'll do, yes.
So if there, your second limb of the submission was if there is a split, that split also, of course, there's no concept of a split in the 10th schedule.
That's right.
But even assuming there's a split in the party, that split is outside the Legislative Assembly, and
Correct.
it can't be that
Correct.
the 56 MLAs decide that, well, we have now merged or we have, there is a split in our party.
It is settled law, Malad. I mean, I'm just indicating
All right.
this is how it happened, but it is settled law that as far as the whip is concerned, and that's in answer to my lord's question, as far as the whip is concerned and the leader is concerned, it's always decided by the party.
That you said yesterday.
Yes, I'm just saying, Malad, the process was in this particular case this. So if a letter is written, I don't know, Malad, we'll find out. I'll find out. If the letter is communicated,
And Mr. Sibal, on that you may be right also for this reason that a whip is a direction to the elected members of the legislature, whether it's in parliament or a legislative assembly or council, that you shall vote in a particular manner, or this is our position on this particular aspect, on the discussion on a bill or whatever you're doing as an elected legislator. Therefore, that direction to the members is also always
by the whip.
outside the
yes. That I'll demonstrate.
outside the legislature.
I'm sorry.
Shows the relevant rules of the
I
legislature.
will, Manoj. I will, in fact, Manoj, I will show that, and it will be clarified. But my lord is right that from the perspective of the format, your lordships may be right that it is forwarded by, but we'll have to check that. But assuming it doesn't make difference to the
Mr. Sibal, why
substance
don't
of
we go straight to the rules of the, because the rules of the assembly
Manoj.
must be telling us how a chief whip is nominated, how a group leader is
No,
who would
rules of the
be.
assembly don't say that, Manoj.
Oh.
There is no rule of the assembly, but this is what has been decided. But this is the convention in every political party. Why, Malas? Because the legislators come into the house on the basis of the symbol given and the election, Malas, pursuant to which they are in the house. They are governed by the discipline of the party, not their internal discipline in the house. And the discipline of the party, I will, please.
So the rules, Mr. Sibal, therefore, rules of the Legislative Assembly are silent. There's no guidance.
No, there is no. But there is also, Malaj, there is a particular rule, Maharashtra Legislature Members Removal of Disqualification Act, under which it is made clear. And that your lordships will find at page 140 of the statute compilation. Just let's go there.
Let's
Malaj.
quickly go to that.
Yes, let's quickly go there. Please, you should go now.
Mr. Sibal, anything here in this compilation so that we are closing it now? We're closing this compilation on our screen so we can go. Anything else?
Sibal.
If there's something else to be shown here, you can quickly show us and then go to the rule.
But let's see this since this question has arisen. Then I'll go back.
So we might as well complete it from this
Mr.
part here.
Yes, just let's complete this part. Let's see page
Mr.
1.
Sibal, if I may, please look at page 710, PDF 723, just in case the essence of the English translation has been lost. This is the same document letter at 710, the same letter that you were pointing out, 25th
Yes.
November 19.
Yes.
It's in Marathi. And that probably will be the essence because it's a translation that you have shown us.
Yes. Yes,
Perhaps
I
Chief-
go by
Chief
my
can
lord, the Chief
throw more
Justice.
light on that. Honorable the
It
Chief
says,
Justice.
गुरुवार दिनांक 31 ऑक्टोबर 2019 रोजी, I mean, I'm sure my learned brothers will get some flavor of it.
No, I
रोजी,
know. I
शिवसेना
can
भवन दादर मुंबई येथे शिवसेने पक्षाच्या नवनिर्वाचित आमदारांची बैठक शिवसेना प्रमुख माननीय श्री उद्धवजी ठाकरे यांच्या उपस्थितीत संपन्न झाली. महाराष्ट्र राज्य विधानसभा निवडणूक 2019 मध्ये निवडून आलेल्या सर्व नवनिर्वाचित आमदारांनी बैठकीची सुरुवातीलाच या बैठकीत होणाऱ्या निर्णयांचे सर्वस्वी अधिकार अध्यक्ष म्हणून शिवसेना प्रमुख श्री उद्धवजी ठाकरे यांना दिले. याप्रमाणे बैठकीत महाराष्ट्र राज्य विधिमंडळातील शिवसेना पक्षाच्या गटनेता म्हणून आमदार श्री एकनाथ संभाजी शिंदे व विधानसभेतील मुख्य प्रतोद म्हणून आमदार श्री सुनील प्रभू यांची एकमताने निवड करण्यात आली. या दोन्ही निवडींचे 2 ठराव पुढील प्रमाणे आहेत. So it says that, well, all the decisions, the power to take all the decisions was entrusted to Mr. Uddhav Thackeray, and an election was then held at which so-and-so was nominated as a group leader and so-and-so was nominated as the chief whip.
Well, that's what I thought, Mulaz. The adhikar was given to him, Mulaz.
And then it is sort of ratified by all the
Naturally, Mulaz.
MLAs.
Yes, yes, yes.
Uh-huh.
So, Mulaz, just kindly come to PDF 55 of the statute compilation. 140?
Yeah, that is.
Yeah, this is what it is, 55. Oh, sorry. So 140, sorry.
And then ठराव क्रमांक 1 also says शिवसेना पक्षाच्या नवनिर्वाचित आमदारांच्या या बैठकीत ठराव करण्यात येत आहे की शिवसेना पक्षाच्या विधिमंडळ गटनेते पदी आमदार श्री एकनाथ संभाजी शिंदे यांची निवड करण्यात येत आहे. That's a resolution. So it's a resolution, as Mukesh Bhai says, of
Mulaz, of the statute compilation, and then I'll come back to the other documents. Let's clear this issue, Mulaz.
140.
Don't say do this, do that. Now kindly see, Mulaz, at 142. PDF, Mulaz, 142. These are, Mulaz, the Maharashtra Legislature Members Removal of Disqualification Act. And removal of certain disqualifications. See paragraph 2 at page 142. Section 2 at page 142. Yes, I hope your audiences are feeling much better today.
Little better, yes. Thank you.
Page 142, Mulaz, section 2.
Just all professional hazards, back, neck.
I know. A person shall not be disqualified from being chosen as or being a member of the Maharashtra Legislative Assembly or Maharashtra Legislative Council merely by reason of the fact that he holds any of the offices specified in Schedule 1. And that at 145 you have Schedule 1, Mulaz. And 23, item 23 there is the offices of the chief whip or whip in the Maharashtra State Legislature. Now kindly read the explanation with me, if your lordships and ladyship has it.
Yes.
The offices of the chief whip, the expression chief whip or whip in relation to the Maharashtra Legislative Assembly means that member of the House who is, for the time being, declared by the party.
Completely redacted, yeah.
I'm sorry?
Was it redacted? It's actually,
They have highlighted it.
Oh, it's highlighted, but I'm getting the highlighting.
So much so that there is nothing except yellow here.
Already highlighted. That's,
मेरे पास है.
I also
Oh, okay.
highlighted.
It's all just yellow.
Everybody.
We all
Very
have.
sad.
Why, Mulaz? How?
I
They
don't know.
must have highlighted it and then scanned it. So
Yeah, so it's come down.
I'm sorry, Mulaz, for this.
Very
Pre-highlight.
surprising. I don't know
I
why.
was also wondering that I haven't done it.
Amira?
I'm surprised myself.
Doesn't matter.
You don't also have it. No, you can read it slowly then, I think.
yeah, give us a copy later, but you can slowly read.
You can.
Yes, it says.
It's my two
office-
brothers and we can share.
also have it.
I'll pass on, Mulaz, sir.
See it.
Can I can share.
We can pass.
Returnable basis or what?
You're giving it to some? Okay.
Pass on another one, please.
I have mine as mine.
Just give another for the Chief Justice, please.
No, I have it. My pen drive is okay.
Okay, all right. Now, may I read, Mills? Yes. The expression chief whip or whip in relation to the Maharashtra Legislative Assembly means that member of the House, who is for the time being declared by the party forming the government to be the chief whip or whip in that House and recognized as such by the Speaker, and includes a member of the House who is for the time being declared as such by the party, having at least 10% of the total members of the House and recognized as such by the Speaker. The expression chief whip or whip in relation to the Maharashtra Legislative Assembly means the member of the House, that member of the House who is for the time being declared by the party forming the government to be the chief whip or whip in that House and recognized as such by chairman, and includes a member of the House who is for the time being declared as such by the party having at least 10% of the total members of the House and recognized as such. It's clear, Malas, that this is, there's no doubt about these things, Malas. I read to your lordships yesterday, in fact, the communication by the chairperson of the UPA to the chairman of the Rajya Sabha that after Mr. Ghulam Nabi Azad, Mr. Kharge is the leader of the legislative party. So on this, there is really no issue, Malas. Back.
Yes.
Now I come back to volume 2, page 17. One second. So, Manas, yes. Then this is, Manas, at 21st of June, a meeting of all members of the Shivsena, Manas, PDF 19. PDF 19.
19.
PDF 19 of Convenience Compilation Volume 2. I'm coming back to that compilation, Manas.
Serial number 5.
Page 6, Manas, otherwise page 6.
Party
Whip. A meeting of all members of the Legislative Assembly on Tuesday, on 21st June at 12:30 has been arranged at the Honorable Chief Minister's residence, Varsha Bungalow. Therefore, all members of the Shivsena should positively remain present for the said meeting. So that's how, Malas, the issue starts. And this is given by the party whip. And Malas, those who are present, they have signed it. We don't have to go into that at the moment. The typed copy is there. And then kindly come to PDF, page 32. As per whip, bylaws have 32 PDF. As per whip issued by the Chief Speaker of Shivsena, Shri Sunil Prabhu, the meeting of members of the Shivsena party was concluded on Tuesday, 21st of June, as Chief Minister's residence at Varsha Bungalow, and under the chairmanship of the party president, Uddhavji. In the meeting, the following resolution was passed unanimously. Resolution Eknath Shinde, the member of Legislative Assembly, has been removed. Forthwith from the post of group leader of Shivsena Legislative Party, Ajay Chaudhary, member of Legislative Assembly, has been immediately elected unanimously on the post of group leader of Shivsena Legislative Party that has become vacant. A copy of the aforesaid resolution, via Article 180 of the Constitution, be forwarded to the Honorable Vice President, Maharashtra Legislative Assembly, who is discharging the duties of the post of President, Maharashtra Legislative Assembly, presented by Ravindra Vayakar and Uday Samant and the others. So, Malas, we change him. The party's decision to remove him as the group leader. Then comes, Malas, PDF page 34, again on 21st of June. Yes, we communicated this decision to the Deputy Speaker, and that your lordships will see to the Vice President, Maharashtra Legislative Assembly.
Page.
It's actually Vice President is the wrong translation, it's the Deputy Speaker. At page 34, Malats, PDF page 34. A meeting of members of Shivsena Legislative Party was held under the chairmanship of so-and-so. In this meeting, the following resolution was passed, Malats, and that is sent, Malats, for appropriate action. Your lordship sees that. You don't have to read the whole document. Sent for appropriate action.
Jai Chaudhary appointed.
Then, Malats, PDF page 36, again 21st of June. Because the party decides to make Ajay Chaudhary the group leader. That also is communicated, Malats, to the Deputy Speaker. And that your lordships will find at page 36. I don't have to read it, Malats, it just be waste of time. That I am directed to inform you that the request made by the above letter to accord approval to the election of Shri Ajay Chaudhary, member of the Legislative Assembly, to the post has been accepted by the President, Maharashtra Legislative Assembly. So he accepts that, Deputy Speaker accepts that. That's how the process is, Malas. Party conveys to the Deputy Speaker accepts it. That's in all assemblies in India, including Parliament, Malas. Then, Malas, kindly come to
1 minute.
yes, Malas, yes.
Both the resolution which you read,
Yes.
the communications, one removing Mr. Eknath Shinde, correct, and appointing this Ajay Chaudhary, were in the meeting of the legislative party. Please see.
Yes, yes.
They were not the decisions taken or the resolutions were passed in the party meeting.
No, but that doesn't happen, Malas.
That-
Never happens.
Correct.
Malas, what happens?
Just for clarity of.
Yes, certainly.
Both these resolutions
Yes.
were in the meeting of the legislative
I
party.
tell your lordships why. Malas, I tell your lordships why. Malas, what happens is, it's the legislative party that has to accept a leader. There is always a consultation with the party. The party is represented by Uddhav Thackeray.
Just what we want to say, speaking of myself, it was not in the meeting of the party.
No, it is never.
Meeting of the
It is
legislative-
never, Malaj, it is never, Malaj. Well, I'm explaining that to you, explaining that. Ultimately, Malaj, a group leader or a leader in the house has to be chosen. Right? So what the party whip and what the leader of the party does is calls the legislators and says, who would you like to be the leader? They take their view and the party takes the decision. It's not a party meeting. Your lordship is right. It doesn't happen in the AICC or the DPCC. It happens, Manoj, with the leader, namely the chairperson or the prime minister, Manoj, acting in his capacity as the head of the BJP. He will be consulted. But it's why? Because it is the legislative members who have to accept somebody as a leader. So the decision is given by the party that this is the person who we choose as the leader. Now you cannot, doesn't happen in the plenary, Madam. That's the process, Madam. Okay. And I will demonstrate that, Madam. Your lordship is absolutely right. Because ultimately, Madam, who has to work? Somebody within the legislature has to work with the leader. Here, they are the ones who are concerned. So their views will be taken and the party will decide.
Yes.
So therefore, they say, okay, let Uddhav Thackeray decide, we'll accept what you say. That's how it happened.
According to you, the decision in the legislative party meeting would always be on the advice of the party.
Always.
That
always.
is what you're
That's right, always. And it's recognized by this court, Manoj, in several decisions. So and Manoj, this is the practice, it's the norm everywhere in every political party.
Leader as well as the whip, both you are saying.
Sorry?
Leader as well as the whip.
That's right, that's right. Manoj, what happens, I mean, I just explained that also. Leadership will decide who the chief whip will be. Leadership will decide who the group leader will be. But the chief will decide, not pursuant to, chief will decide, carry out the instructions of the leader when matters are in the house. There, Manoj, the leader doesn't come in. Chief whip will say, we'll go to the leader and say, look, this is the issue before the house. How do we deal with it? Leader will discuss it with the chief whip. Chief whip will communicate. That's how parliamentary democracy works.
Yes.
But your lordship is absolutely right, and it's a good point that your lordship has pointed out so that I can clarify it. Then let us kindly see 22nd of June. In the backdrop of causing party crossing over and thereby attempting to destabilize the government, and considering the consequential political situation that has been created in the state, an urgent meeting has been arranged on 22nd of June at 5 at Varsha Bungalow, Mount Pleasant Road, to face such situation. Your presence for this meeting is necessary, which please note. The said notice has been forwarded on your email ID registered in the Maharashtra Legislative Assembly. That apart, you have also been informed through social media, WhatsApp and SMS. You cannot remain absent for this meeting unless valid and sufficient reasons in writing is given. If you fail to remain present for the meeting, it will be presumed that you have clear intention to leave membership of Shivsena party voluntarily, as a result of which action as provided in the Constitution of India with respect to disqualification of members will be taken against you, note of which is taken. This is communicated to Eknath Shinde by whom? By the whip, by Sunil Prabhu, who represents the party.
So is it a typo at the end of that chief speaker? It should be chief whip.
Yes, it's chief whip, not chief speaker. It must be a translation issue.
Yes, it's I was reading the Marathi, it's chief whip.
Yes. And then, the 22nd June notice is sent, which is PDF 39. In the background of the recent concluded Maharashtra Legislative Council elections held on 20th of June, and in view of the volatile political situation emerging in the state on account of repeated attempts being made to destabilize the government by orchestrating defections within the Shivsena, and to discuss and draw out a political strategy to address and contain any such exigency, you are urgently called upon to attend the meeting of the Shivsena Legislative Party today, on 22nd, to be held at so-and-so place. Please note that failure to participate in the meeting without providing valid and adequate reasons in writing, communicated in advance to the undersigned, will result in consequential action against you under the relevant provisions of the Constitution. This notice is being sent on email address provided by the legislatures and registered with the Maharashtra Assembly, along with soft copies being served on SMS and WhatsApp as well. This again is sent by the Chief Whip Mullahs and Mullahs.
What page is this, sir? What page is
Next document is
26?
page 40, PDF page 40, 22nd of June. Says, subject notice of Shivsena Legislative Party meeting. An emergency meeting has been organized on Wednesday, 22nd June at 5 p.m. at Varsha, whatever, to deal with situation as there is an attempt to destabilize the government by shifting parties in the background, and therefore the political situation created in the state. It is important to note that this meeting requires your presence. Notice has been sent to you by email. You have registered with the Maharashtra Legislative Assembly. In addition to you, then SMS, WhatsApp. It should be noted that if you do not attend, Malas, then you're liable. In accordance with the Constitution, action will be taken. This is sent by the Chief Whip, and then this is sent to all these people, and they don't attend. Then your lordships may go straight away.
What is the annexure 10?
Annexure?
Annexure 10, that is the next page of PDF 41.
There's those people, Malas, who attended and those people who didn't
Those who
attend.
attended.
That's right. That's what it is. Yes. Now, Malas, now comes the document, which is, Malas, crucial for this case.
What is that document, Mr. Sibal?
This is at PDF 51. This communication which I have read was sent to Eknath Shinde, Malas, by the Chief Whip. Now Eknath Shinde replies to it.
Just 1 second.
Not Eknath Shinde, but Kopri. I see. Oh, that's the constituency now.
Sunil Prabhu. By Eknath Shinde.
Now kindly see to Sunil Prabhu this document. Now it says, you have misused the authenticate letter of the office of the Shivsena Legislative Party. A meeting of 45 MLAs of Shivsena Party was held under the chairmanship of Honorable Group Leader Eknath Shinde, and in the said meeting you have been unanimously removed from the post of Chief Speaker of the party. Chief Whip of the party, Shivsena MLA Bharat Gogavale has been appointed as the post of Chief Speaker, Chief Whip of the Legislative Assembly. As per letter of 22nd June, Shivsena Legislative Party Office, despite you having no authority to sign, has sent to me notice which is legally invalid. You have no right to send me the said notice. Therefore, it is not binding upon me to remain present. Now, Malas, this act, the fact that you did not attend the meeting, the fact that you wrote this letter, the fact that you appointed the Chief Whip, you 45 people or whoever, whether it's 40 or 45 at the moment, we're not on that you are members of the Legislative Assembly, you have appointed your own Chief Whip, you say that you are no longer the Whip. Malas, is all, Malas, there is no, as far as I am concerned, Malas, this is per se illegal. This doesn't emanate from the party. He cannot, members of the legislature cannot, Malas, pass such a resolution, cannot defy the whip, cannot remove the whip. So the 40-odd members, Malas, sitting in Assam convert themselves into the party and decide to remove everybody. The next document is at page 52. Again, June 22nd, 2022.
52.
Same thing, Malas, that you have misused the official letterhead in a meeting of 45 MLAs held under the chairmanship of Group Leader Eknath Shinde. You have been unanimously removed from the position of Chief Whip. So he is acting as a group leader of the members of the legislature. So therefore, Malas, let's put it in simple terms. In any assembly, 10 people can get together and remove, Malas, the Chief Whip. And then they can go to the opposite party and, Malas, with the numbers game that is going on, they can they can actually destabilize the government and have their own chief minister. This is the outcome if this is upheld to be, if it is held to be valid. If such an exercise is held to be valid, the outcome is that you can remove, an elected government can be removed any time depending on the arithmetic.
To put it on the flip side, therefore, Mr. Sibal, your contention would be then, if this outcome has to be lawfully achieved of removing the Chief Whip or the group leader, then what is the course of action to be followed according to you?
You have to go to the party, call a meeting of the party. Call a meeting of the party, or you merge.
Party would mean the national executive, or what would it mean?
You have to call Malas, the national executive, the Pratinidhi Sabha, the general body, the Pratinidhi Sabha. not the Karyakarani, Malas. That's a 13 members. The Pratinidhi Sabha has 262 odd members. Malas, point is they have never been to the party.
Of course, the only chink in that submission, I mean, we must put it to you straight so that you can deal with it, is that that was not the process which was originally followed when the chief whip or the group leader was nominated, unless we also postulate that when the group leader and the chief whip were originally nominated, Uddhav Thackeray was acting as the party.
Yes, because he was neither a member of the council nor was he Malas, the chief minister. He was nothing. He is the Paksh Pramukh under the
Because
constitution.
one thing, as Brother Justice Emma Shah pointed out very clearly, it's obvious that the appointment and the nomination of the group leader and the chief whip was made at a meeting of the MLAs. Now, because it clearly says Amdarancha Baitakit. But
Answer that straight away, Malas.
but it is also in the presence of Mr. Thackeray, and the MLAs begin by saying that we are assigning to Mr. Uddhav Thackeray the right to take all decisions.
Right.
Then they pass a resolution at a meeting of the MLAs. So it's a sort of a hybrid situation where the group leader, power to nominate a group leader and the chief whip is delegated to Shri Uddhav Thackeray. But there is a, so to speak, an anointment of them at the meeting of the MLAs. So the only way really that can be, the two can be reconciled is by postulating that in that sense, at the original meeting, Mr. Uddhav Thackeray was the party. He was, whether you like it or not, he was the party. It was not a meeting of the national executive. It was not a meeting of the plenary of the party. But he was really the whole and soul because he was not an elected member at that point of time at all.
He was the president, Malas, of the party.
He was the president.
Paksh Pramukh.
He was a Paksha Pramukh.
Yes. Malas, it's very interesting your lordship raised this. Let's analyze it. Let's, Malas, analyze the circumstances against me. Let's assume this all can be done within the legislature. I'll assume that, Malas, that the party has no role. So, Malas, therefore, 50 people in the house can actually have a leader in the house without reference to the party. If that logic is accepted. 50 members of the house can actually oust the party whip appointed by the party. That's the consequence.
When were the elections held? I think
2018,
the first document at page PDF 14,
23rd January 2018.
17th February 2018.
No, but that's the communication, but the elections are 23rd January
23rd
2018.
January, it speaks about that.
Yes. The point that I'm making to your lordships is, this is unheard of in any democracy, in any legislature.
Elections were held on 23/1/18, you said, right?
23.
Yes. Malas, it will be entirely unworkable. Because you will then say that there is no relationship between the members of the legislature and the party. They are independent of the party, they can take whatever decision they like. It will be destructive of, if you ask me, the basic structure of a system of governance, which allows the party and the legislatures to be intertwined in matters where, Malas, the decisions have to be taken on various very significant issues as they come up in the assembly or in parliament.
Well, you can tell me later, but what I want to know, this letter speaks about organizational elections.
Yes.
It talks about organizational
That's correct.
elections. So what are this? It is to the different tiers, is it?
Yes, it's in different tiers.
There's something called a general body, is it?
There is a Rashtriya Karyakarani, which is the national executive, 13 members. Then there is the Pratinidhi Sabha, which is about 262 members.
What is at the bottom?
Sorry?
What is representing the general body?
Pratinidhi Sabha.
Pratinidhi Sabha.
Pratinidhi Sabha. But of course, you can't hold a meeting of all the members of the party all over Maharashtra.
I'm just asking for information.
Yes. So there's a tier system. There's a tier system.
Is virtually like a general body.
Yes. There's a tier system by which, Maharaj, people are both appointed and elected.
In
Appointed,
Prathinidhi Sabha.
yes, Prathinidhi Sabha.
And Mr. Sibbal, possibly this line of argument of yours is also buttressed by 2B of the 10th
Yes,
schedule,
yes.
which says if he votes or abstains from voting in such house, contrary to
the
any
whip.
direction issued by the political
That's
party
correct.
to which he belongs,
Yes,
or by any person or authority authorized by it in this behalf.
that's correct.
So the whip is really a person who is authorized by the political party.
That's correct. That's correct. That's how it functions, Mullah. That's how the
Because the direction has to be given by the political party. It can't keep on giving a direction. It's a larger body.
Yeah, that's right.
So therefore, it delegates its power and it authorizes a person who will then issue a direction on which way to vote in the assembly.
In matter when it came up before the law commission, it will be disastrous for democracy, disastrous for the country if the legislative party is allowed to act independent of the political party.
So the actual whip, without, it says, or by any person or authority authorized by it in this
That's
behalf.
correct. I read that.
So yes, so the party really nominates or authorizes a person.
That's correct.
And the act of defection lies in
Correct.
voting or abstaining from voting contrary to a direction given by the party or by that person.
Because I want to ask
authorized by the
myself,
party.
supposing there's a bill in parliament, the legislative party on its own can't decide what the position will be.
Right.
It cannot. Naturally, there'll have to be consultation with the party. Because they are not living in a side, they are not acting as a separate entity.
They are really the voice of the party in parliament or the state legislature.
That's correct.
It's the political party.
The genus is the party, they are the species.
Yes.
Yes.
Political party which either sends the MLAs who, because of majority, form the government.
Yes.
Or they could even send members of legislative assembly who will be sitting in the opposition.
That's correct.
So nevertheless, the controlling factor
Has to be the party.
will be the political party.
Yes.
Which will, through its MLAs, operate either as
because they are there because of the party.
Their mandate is the mandate of the party.
That's correct.
And therefore, how they function in the house is determined by the mandate which has brought them into the house.
That's correct. Exactly, Madam.
You have no and I think that seems to be a fair understanding of the 10th schedule also.
10th schedule has
to be linked to it.
Mullahs, you have to maintain the integrity of the political party within the house, its programs, its views on reservation, its views on the 10th schedule, its views on Mullahs, foreign policy. Individual members of the legislature don't decide on foreign policy issues, Mullahs, the party decides. And party systems are such that you have committees where people who are in the past also, who are members of the party, who have experience in foreign policy, who've been ex-ministers of foreign policy, they become members of the committee, they advise the party as to what position should be taken, and a matter comes up, the legislators are only told that this is what should be done. Within that framework, you can make your case out.
So they articulate the views of the party in the House.
That's correct.
Yeah.
One important distinction is, sorry.
Go ahead.
No.
As you tell them.
Well, just to take 15 seconds, a bizarre example of how the party governs. Very interesting, apropos Lordship, because I happen to be chairman of the Parliamentary Standing Committee on Law in 2011, and the most contentious Lokpal bill came. We had a report signed by all except 3 dissents. 3 dissents are all, every 31-member committee, which is a mini parliament, everybody signed, all political parties, 17 political parties. Matter went to Rajya Sabha. All of them supported the report because they had signed it. Overnight, whereas the party stand of one particular party, I'll not name it, changed. The matter came to Lok Sabha. The same party which has signed took a different stand in Lok Sabha because the instructions from the party to the legislative wing of the Lok Sabha was that no, this has to be opposed. Lokpal has to be opposed. This is in the record of Parliament. So as the party decides, this is an extreme example that the party which had agreed with the report actually opposed it in Lok Sabha because the members are only legislators, but they received the instructions. It's an important, well-known regional party, but the policy changed that no, we must oppose Lokpal, therefore it was opposed in Lok Sabha. So that was the best validation of this kind of example.
Any number of examples like that. Any number of examples.
It's a reverse engineering.
It's a political issue on so many other factors.
The legislative members controlling the party is actually reverse engineering.
Yes, Your Lordship is right. Exactly. Therefore, these documents become exceptionally important because they will determine the outcome of this litigation. if you give validity and legality.
So, Mr. Sibal, we have seen all the documents now?
Not yet, Maharaj.
All
Not
right.
yet. I'm
No,
just-
because the next step I was going to request you to formulate it in 2 or 3 submissions for us, but you can complete the documents and then
Yes,
give us
Maharaj,
a
yes.
reformulation of 2 or 3.
No, Maharaj, then I have to read your lordship some judgments which actually deal with this.
Before we go into the judgments, you can just formulate it for us in
Yes,
2 or
I
3
will.
submissions.
I
We'll
will.
take it down, but
I will.
let's complete the document,
Yeah.
then the formulation and then the judgments.
Yes, let me just quickly go through the documents now.
Yes.
So page 52 I've read. Then kindly come to Maharaj's resolution of the meeting of the Shivsena Maharashtra Legislative Assembly 1919 to 2024. Maharaj, that document is at page 50, PDF 55. Now, Maharaj, this is what is passed. Very interesting.
What is the date?
Maharaj, it's signed by Bharat Gogavale. Very interesting document. This tells you the story, Maharaj. Resolution of the meeting of the Shivsena Legislative Assembly. Maharashtra Legislative Assembly 1919 to 2024. We, the following members of the 14th Maharashtra Legislative Assembly, belonging to the Shivsena, we are notified as the members of the Maharashtra Legislative Assembly as members of Shivsena Legislature Party. We had unanimously elected Eknath Sambhaji Shinde on 31st October 2019 as group leader of the Shivsena Legislature Party. There was a pre-poll alliance between the Bharatiya Janata Party and Shivsena Party for the 14th Maharashtra Legislative Assembly. There has been great dissatisfaction prevalent among the members of our party, Shivsena, and our party cadre at large on account of corruption in the government, administration regarding police posting, corruption by then Home Minister so-and-so, sitting minority minister so-and-so. Apart from above reasons, our party cadre faced tremendous harassment and distress on political as well as personal grounds. From the opposition, ideological parties who are now a part of the government and were using their office and power to undermine the base and foundation of Shivsena. There is enormous discontent amongst the cadres of our party, Shivsena, for forming the government with NCP and INC, who are ideologically opposed to our party. There has been a compromise on the principles of our party, Shivsena, which has been a party of fierce ideological base and was formed for fighting for the rights of local Marathi people. For last 2.5 years, our party and its leadership have compromised party principles by aligning with the contrasting ideologies for the sake of achieving power. The ideology of our party leader, late Bala Sahib Thackeray, was to give a clean and honest government to the people of Maharashtra, and also without compromising on the principle of Hindutva, which was defeated on the first day itself by aligning with the opposing ideologies. Shivsena and Bharatiya Party has forged a pre-poll alliance for 2019 Maharashtra Assembly. They sought the blessings of the voters of the Sena-BJP alliance, which the voters accepted and voted in favor of alliance. After results were out, the Shivsena severed its ties with the BJP and formed an alliance with the opposing parties, which they had fought against in 2019. This act of our party leaders had a tremendous negative impact upon the voters and the party cadre. There was a continuous hue and cry towards party leadership for the act of aligning with the opposing parties. Ignoring this, party leadership went ahead and formed the Maha Vikas Aghadi government. For the last 2.5 years, we, the Shivsena Legislative Party members, were facing tremendous pressures from the electorate. We, the members of the Legislative Party, as well as all leaders and workers throughout the country, were facing a lot of humiliating questions. Our leader, Bala Sahib Thackeray, was always a strong nationalist. We've also been subjected to a lot of criticism for being part of the corrupt Maharashtra. In view of the above, the members of the Maharashtra Shivsena Legislative Party have met today and resolved this under. What have they resolved? Hereby resolved and reaffirmed that Shinde, who was appointed as leader of Shivsena Legislative Party, is and continues to be the leader of the Shivsena Legislative Party of the 14th Maharashtra Legislative Assembly. And this is Mother's proposed and seconded by members of the legislature. And I hereby further resolve that Bharat Gogavale, elected and appointed as Chief Whip of the 14th Maharashtra Legislative Assembly, is cancelled with immediate, and Sunil Prabhu is cancelled with immediate effect, proposed and seconded. Now, Malas, there is no reference to any meeting of the party. There is no reference to any grievance made prior to this date. They are all members. He was serving as a minister for 2.5 years. There is no reference to any grievance that he has ever had. No reference. No reference to any statement he made in any organizational election. No reference. suddenly could not have happened on the 21st of June, Mullahs. This sudden realization that this great injustice has been done, Mullahs. Obviously, this was planned. Mullahs, if anybody had any grievance of this nature, it would be in public statements, it will be in organizational meetings. After all, this is from 2018, we are in 2023 now, Mullahs. Not a single statement anywhere. So obviously, and what this statement is being made from Assam. Why Assam? So it's not something, it's all pre-planned, it's a conspiracy. It's not something that happened overnight. And you're talking about poll promises. Let me, Mullahs, talk of history then. Mullahs, the poll promise was broken at the time when Mullahs, Devendra Fadnavis and Ajit Pawar were sworn in the early hours of the morning by the governor. What about that poll promise? So let's not go into politics.
I was just going to say that now you are trenching into an
No,
area
no.
of politics.
No, but this is all politics.
You're now leaving the area of constitution.
No, I know. But Munir, I said it in the context of the grievance that he has made. He has made a grievance of poll promise.
No, we are not at all, Mr.
Yes.
That will not.
So, Munir, let's go. That's why I said we are. I'm sorry.
Yeah,
I'm-
but in state, sir.
But therefore, Mr. Sibal, ultimately, I mean, we're just sort of pushing your argument to its logical conclusion in constitutional terms.
Yes.
Therefore, what you are saying is that, look, when Eknath Shinde was nominated as a group leader and the whip was then nominated, the whip was also notified, it was at the behest of the party,
Yes.
albeit at the MLA's meeting.
Correct.
An alteration of that position was made at the meeting which was chaired by Mr. Uddhav Thackeray. The legislators could not have either abstained from the meeting, which was convened by the party president, nor could the legislators have replaced the whip or the group leader.
That's correct.
So that all that they did was really therefore was contrary to law and therefore invited a disqualification under the 10th schedule. All this really then leads us to this, that therefore they have incurred
The disqualification.
they have incurred a disqualification.
That's correct.
Now, having said that, therefore, this is therefore a case where the speaker has to ultimately decide upon the disqualification which they have incurred, isn't it?
Absolutely.
I understand.
That is, Mr. Sibal,
what
that is
it
an area which we are not able to come to bridge.
I will, Maharaj, I will. Yes. 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 Yes, I made that argument. Maharaj. Yes. I will try and, Maharaj,
Of course, the constitutional position of the speaker to decide.
Maharaj, I tell your lordship the problems in that area. But kindly
There's
just,
problems in the area, we see that. But,
We understand.
also we understand the significance of the point which you have made, which is a very significant point for constitutional democracy, that ultimately the party is supreme.
yes,
And legislators get there into the House or the Parliament or the Legislative Assembly on the mandate of the party, what the party means to the people.
correct, correct.
Therefore, you are really elected as a representative of the party. Your behavior must be governed by what the party dictates.
Yes.
And a group of legislators, whether you are 1/3 or 1/10
Doesn't matter.
or even 75%,
That's right.
cannot be really determinative of the wishes of the parties. You can alter that position if the party authorizes you or
Correct,
you leave the
correct,
party.
Correct.
So far, so good. I mean, that's a very significant point which you have made. But
I understand.
the
point
point,
is-
the
The next
next
point,
point, I
the
mean,
next
what is the
point.
consequence?
Yeah, I will, but I'll
That is-
attempt.
Which you are really telling us that, look, the facts stare you in the face. Now, why go to the speaker?
Yes, that's what my submission is. What is
There are
it that the
twofold.
speaker is going to do in this?
It could be twofold. One, as you say, well, the speaker himself cannot be trusted as an impartial arbiter.
I withdraw that, Maharaj, because we are talking about the constitutional
That's
position.
right.
Maharaj.
The second would be where the facts are so clear.
Yeah,
Then you take the decision with the
Yes.
speaker ought to have decided that there is only one and one conclusion.
that's right.
That, Mr. Sibal, honestly,
Speaker
that
has to
is
decide.
that is a matter of disquiet for speaking for myself. I mean, should the court be taking into that, entering into
well,
that area? That's an area
Your
of
lordships have been persuaded in the past. I hope to persuade you in the
That-
future as well.
it has very serious ramifications. Just
but
as
then-
yours, the ramifications.
I will, Maharaj, address your lordships on that.
The ramifications which you have referred to for constitutional democracy, if individual legislators start bucking the party discipline, Really, there are very serious ramifications if we start taking over these functions.
Very
you know.
dangerous.
No, Malas, what happened was,
Very,
in one particular case, which is the Constitution bench, Malas, where they said that this illegality cannot be continued even for a day. So we will take the decision.
because
They are occupying the post of the minister. This cannot continue even for a day. I will not send it back. We will
right or wrong, this is the system which we have now assumed to ourselves as we the people. And when the courts try and breach the system, it's a very
No, Malas, I understand.
that's what is worrying us. I mean,
Malas,
put it to you right up at the forefront.
Quite frankly, a constitutional court should be worried, because if you create this as a precedent, it can happen in other situations as well, and that not be a good precedent. But I am not disputing that. Please, I am not. I know the limitations of a constitutional court. I know that, Malas. But what has happened in this case, unfortunately, is that this has happened because of a judicial order. This would never have happened.
All right, we also go to this extent that, if a situation transpires because of a judicial order, we are not saying that it has.
Yes,
we are
I
for the-
understand that.
for
I
the
understand.
your argument.
Yes.
And therefore, it's the duty of a court to rectify a
That's-
situation which emerges as a result of its own order.
That's right.
All right. In various other contexts, we always say active
You have said that in several judgments, Malas.
eminent gravity.
Yes.
But assuming that is so,
Yes.
and we place ourselves in the position in which the court was, say, immediately before the 27th,
Yes.
what would the court then have done? That, look, let the speaker decide. Keeping aside the issue of 2-day or 7-day notice.
Yes.
Let the speaker decide.
Yes.
So if we have to restore the position as it would have been, but for that order of the 27th, we would have said, let the speaker decide.
Yes.
Possibly,
Even today.
your argument would be, until the speaker is deciding, no trust vote. Let them take a decision first, and then, because the trust vote would be.
Because everything helped there after that happened because of this order.
But therefore, if you have to restore the situation as it stands immediately before the interim order of this court, we can restore it by saying that, well, the speaker has to take a decision.
Right,
as
as
of that
of
date.
date.
Yes.
Had they incurred a disqualification.
Yes.
But it would be very difficult for us to take over that function.
Malas, I don't mind, Malas. Let that deputy speaker decide. I have no problem with that. That's what happened in
Therefore, which deputy speaker?
the speaker, Malas, who was denied the right to continue with the disqualification. This has happened in the other case.
So then we restore a putative state of affairs.
Yes, your lordships have done
completely
that.
overtaken by events.
In Nabam Nemia, your lordships have done exactly that. Exactly that. Because when I argued this before the Constitution bench then, I said, my lords, what is happening is you let things happen and then you will tell me later that we can't reverse it. He said, no, we will reverse
Mr.
it.
Sibal, then you support Nabam Rebia's course of action when it suits you. And when Nabam Rebia is creating a problem, you wanted to.
No,
refer
Malas,
to
that's
larger
because there are
bench.
two different issues in Nabar Nebia, Malas.
All right.
Well, I'm sorry, Malas. You can't put that
No,
argument.
we're not at all.
There are two different issues. Malas, in fact, I was wondering when your lordships are going to decide to refer it to 7, because this is a real problem. Because that's intrinsically at the heart of the matter, which is why I said you take it up as a preliminary, Malas, submission. Malas, because ultimately this can only be decided.
But Mr. Sibal, look at the consequence. You today have a speaker. You have a speaker in a democratically elected house. Tomorrow you may have a speaker in parliament. Can the Supreme Court say, sorry, we are now overriding the mandate of this speaker? We will retrace our steps back to say now something which is 8 months ago, restore a speaker who is now no longer holding the office of the speaker, and we tell you, we now decide that somebody is the speaker.
He's still deputy speaker.
Huh?
He's still deputy speaker.
And ask that
But
speaker
he's
or
still
deputy
deputy
speaker
speaker,
to take a consequence. I mean,
He's still deputy speaker. Malas, all right. Well, one second. Hold on. You got a lot of hurdles to cross. But anyway, let me.
you're all very seasoned constitutional lawyers, but you know what is
Yeah,
worrying us.
No, I'm not going
You
to. I'm not
understand
going to
what is worrying us.
make a proposition that will in fact destroy the fabric of a constitutional structure that has been in place since independence, since we were a republic. I'm not going to do that. But see what has happened. First of all, the no stays, I mean, they are given time till 12th July. But more important, On the 29th, this court says that we will set aside everything that happens thereafter. See, Malas, where we are now. We say, please stay everything. Don't allow the trust vote to happen. Decide this matter. It could have been decided on the 12th of July. Then the court tells us, no, doesn't matter. On the 29th, all that is subject. Now your lordships are telling me, how can it be subject? Now your lordships are telling me, rightly maybe, that how can we go back on 27th? But that's exactly because of the two court orders. What do we do?
But the court order was also prompted by what your speaker did.
Now, I said, you stay. Don't allow them to take the oath. Don't have a trust vote. We said that. Then on 29th June, that order is passed. Thereafter, all matters are placed.
Had your speaker chosen to follow the law by giving them 7 days
No,
notice,
the law is Naban Rebia. The law is hollow on.
The court would have said, all right, go and respond to the
law is hollow on. I tell your lordship now, I can't in hindsight say what the court should have done was stayed everything, allowed them to file a reply and allow after 12th of June for the speaker to decide. What is the problem? There was no problem. But the status quo changed. Well, they were given time till 12th of July. All right, let them give time. Despite the fact that it is contrary to Holhorn, forget it. They should have been given time. They should have filed a reply. The deputy speaker would have decided, why allow the status quo to be changed? And that also, because a judicial order says, doesn't matter, even if the status quo is changed, we'll restore it back. So we had two judicial orders then. And now your lordship rightly puts now under the proceedings of the House, a new speaker has been appointed. But then you yourself said that we will deal with it. All that will be subject to.
So essentially, we'll therefore have to invalidate the trust vote which took place on the...
Because it was only on the basis of these 39
a trust vote which we will have to invalidate, a trust vote which never took place. So
No. Even the trust vote that took place on 4th is subject to, Manoj. I'm sorry. All other actions are subject.
My learned brother just...
I'm sorry.
You challenge. Just what,
Yes.
on
Yes.
your submission, that as per the interim order dated 29 June, correct, all subsequent proceedings are subject to ultimate.
Yes, yes.
Now see, factually, we have to consider that. On 29th, you challenge the trust vote to be held on 30th June,
Yes,
correct? You challenge that only.
that's
on
correct.
29th,
That's correct.
correct? Now see the order, interim order, which is passed by this court on 29th.
Right.
See, please read it.
Yes, please. I'll read it. What's an order compilation, Malas? Let's see that.
That is, I think on page.
Page 7 of the order compilation. Volume
Orders
17.
compilation, volume 1.
Volume 1.
Yes, I have it. PDF pages 7.
Order dated 29 June.
It starts, we'll just see, Malas.
PDF 8 at 10. Para 8. Operative.
I'll just read it.
This is the PDF.
Yes. Page, Malas, the writ petition is ordered to be listed for hearing.
Para 8,
Para
para 8,
eight.
maybe straightway you.
Right, having given our thoughtful consideration. That's the one?
Yes.
Yes, yes. We do not find any ground to stay convening of the special session of the Maharashtra Vidhan Sabha tomorrow at 11 a.m. with the only agenda of a trust vote. The proceedings of the trust vote to be convened on 30th shall be subject to the final outcome of the instant writ petition as well as the writ petitions referred to above.
Correct?
Yes, and the special session of the Maharashtra Vidhan Sabha shall be conducted. So as well as writ petitions referred to above.
Okay, but what
Writ petitions referred to above is that
was the subject to ultimate outcome? The proceedings of the convening the meeting on 30th would be subject to.
I agree.
Not all the subject.
Malas,
proceedings.
I don't dispute that. I'm saying,
The fact remains that on 30th June, for whatever reason.
I had resigned earlier.
The trust.
Your Lordship is right.
At all.
Your Lordship is absolutely right. But Malas,
Your submission that all other, as per the order dated 30th June, all other subsequent will be subject.
Malas, I just asked myself a simple question. Had I not resigned, that trust vote would have happened and I would have, the same thing would have happened.
Correct.
The same thing happened on the 4th.
Right, counsel.
The same thing happened on the 4th.
Provided the meeting would have been convened on 30th.
But the same thing happened on the 4th. The trust vote happened on the 4th. And that is also subject to, writ petition was filed. Your Lordship said we will consider that. That will also be subject to.
No, we were on your submission.
Lordship is right. I mean,
Technically,
technically, what my Lord is saying is absolutely right. I cannot have any two opinions. There can be no two opinions. But the fact is, in substance, it's the same thing.
that's it.
Whereas, yes, your Lordship is right. I mean, I can't get away from the fact that he said, what's the point of going to these people are going to vote for him. That's exactly what happened on the 4th. That's why we challenged the 4th. That's also, the writ petition is here. So, are we going into the technicality or are we going into the substance of the matter? Whether these 39 could have voted in favor despite the whip. There is a whip issued, Maharaj, on the 3rd. Whip is issued on the 3rd that you vote against the trust vote. They did not. And who is the whip? Sunil Prabhu. Voted against the whip. So, Maharaj, where does it take us? It doesn't take us anywhere. So he votes against the whip, and Maharaj, Gogavale is then appointed. He can't be appointed by the speaker. And Gogavale, they have issued, speaker has issued notice to us. Those notices can't be issued. I can't be subject to any disqualification proceedings. And my notice has been given by the speaker to me to be disqualified. Your Lordship will strike it down on the facts. So all these issues will have to be decided, Maharaj. I'm sorry.
Which are the issues that you want us to decide?
That's exactly what I just show. Let's give it to my lords. No, let's give it. I'm sorry, Maharaj, it's taken.
Responded yet.
Maharaj, they will have. Through, Mother,
Yes.
what your lordships might
That
might or might not wish to decide.
no. The crucial facts which you have
It's not finished yet, Mother.
told us, leading to the 22nd.
Yes.
I think those are completed, right?
Yes, those are completed. Then what happens thereafter, Mother? Another letter is, Mother, the letter of 22nd.
To the notices on the 10th schedule notices.
That's correct. That's correct. And thereafter on 24th, another notice. Then on 25th.
We are aware of.
Mr. Sibal, we were at page 55 of that.
You want me to
compilation.
finish that first,
So
Mother?
that, that part is
Quickly
over just
indicate
for the
those
sake
dates,
of
Mother.
completeness. Let's,
All right, we'll do
then
that.
Quickly indicate those dates. And
Yes,
we
we'll
can
do
just,
that.
let's go to page 55. We were at page,
Yeah, I'll
PDF
just
page.
go back to my document. Let's the convenience compilation of.
2, right?
Convenience compilation.
I got it.
2 at
We are
page
at 49, Mother. Now, this is that PDF 62. This is that document which your lordships have already read. Dated 22nd, dated 21st, but served on 22nd at 11:30, which your lordships have already read.
This is the important.
let's make a note of it since we are
That's right. I'm not going to read it.
relevant for Nabam.
page 62, right?
Except, Mother, the fact that they are the majority, no other cause was shown. So 179C, I've made my submissions on 197C already, Mother. So, and this is connects with Nabam Rebia, this document. So that issue is over. Then kindly come to, Mother's page, PDF, Mother's 71. This only gives you, Mother's, what is happening. 40 members from the MLAs in Assam. No dispute on any of this.
Then next.
And then is the disqualification petition filed on the 25th.
Page 62.
Well, that's at page 72.
Mr. Sibal, page 62 PDF that we've just touched upon, notice to move a resolution. What does para 2 say?
At page 62.
Yes, please.
Yes, I just. Para 2 says, Malaz, we all respectfully submit that you no longer have the right to continue as Deputy Speaker, as you no longer enjoy the support of the majority of the House.
The House.
More particularly, the following
Is that
members of our
what you-
party.
Majority of the House.
Yes,
Is that what you're trying to, this is your emphasis?
yes,
That here,
yes.
also the references to the majority of
In the House.
And goes on to say particularly the following members of the party.
That's correct. Because, Malaz, what is party means? The legislature party.
No, that's not quite correct. Brother, my learned friend repeatedly says this. But every member of the Legislative Assembly and of Parliament is ex officio
Yes, yes.
member of the Pratinidhi Sabha.
That's
We
correct.
are also part of that.
That's right. No
And
doubt.
everyone else
One second. Hold on,
Sabha
hold on,
is
hold on.
appointed by the-
Hold on.
There is an overlap.
No dispute.
Aware of it.
The 39 members of the legislative party are also members of the party. No dispute.
No question about it.
No, how am I? I have not said anything
They have
contrary
to have
to that.
primary membership. of the
Yes,
party.
yes.
That's a-
I have not said anything against that. Only thing is that 39 members can't hijack the party.
That's all.
That we'll see. That's the issue. Of course, we welcome you. It's all right. No. Let me continue, please.
Next.
So, Malas, your ladyship was right. Exactly, Malas. Then kindly come to
59.
59, Malas.
PDF 72.
No, first, Malas, yes, 71, PDF 71, page 58. Maha trouble for Uddhav, Hemanta meets Eknath, 40 MLAs in Assam. Photographs
Sorry,
there.
where are you? The Hindustan Times article.
News, Hindustan
yes.
Times article.
That's to show that it's reported.
It just shows, Malas, that, the surroundings are comfortable.
Relevant for 10 schedule, no doubt. Not for a speaker. Relevant.
Then, Malas, the notices.
Inference.
Now it's the notices we don't have. No more Malas documents. All kinds of statements have been made, Malas, that we are following a separate party, but that's all happens in Assam. It's a given, Malas, so let's not go into that. So this is all, Malas, as far as the documentation is concerned. Now let's see, Malas, what the issues are. The first, Malas, deals with Nabam Rebia, basically, so that your lordships will have to decide. That is, does the Constitution permit an institutional hiatus by tying the hands of the Speaker in functioning under the 10th schedule through proceedings initiated by a member of the Legislative Assembly under 179C? That I've argued that your lordships will decide. All I can say in that regard is that if you allow that law to stay, it will be misused, it will be a new model of toppling governments. Safety valve for defectors. Now, the second, what are the consequences in law when members, whether in minority or majority, of the legislature party in the House, act dehorse the political party and are contrary to the directions of the political party and assert their separate identity by forming a separate group within the legislature party in the legislature? Squarely, Malas, that's an issue. Squarely. That can, in any legislature, X number of people form a separate identity and say, we'll not listen to the party, we'll decide what to do.
That you've been arguing yesterday.
Will a group, will a group within the legislature party asserting their separate identity and acting towards the political party or contrary to its directions have per se incurred disqualification under para 2 of the 10th schedule? There's no evidence to be led here. Admittedly, there is a whip, Sunil Prabhu, on the 3rd, saying vote against the trust vote. Admittedly, on the record of the House, they voted in favor of the trust vote. Even by that time, Gogavale had not been appointed by the Speaker, though the Speaker has no right to appoint Gogavale. He appointed Gogavale on the 3rd evening, which he can't do otherwise, but that's another matter. So, Malas, what is there for the Speaker to decide? There's a violation. The vote is on the record. You're not usurping anything. You're only declaring.
This question is incoherent. This issue is incoherent. What is the logical follow-up? Then
No,
the Speaker will say it's per se case.
I'm sorry?
Speaker will say it's a per se case.
Yeah, I hope so.
You are.
I hope so, Malas. I hope so.
That's different matter. What you're trying to say in 3 is, in per se cases,
Yes.
should the court not decide?
Yes, that's the point.
That's
That's why I put per se there, Malas, only for that reason.
God.
So it is incoherent.
Malas, we have to ultimately persuade you, Malas, so we have to. I always say, without the court on your side, there's no point arguing. And the only way to have the court on your side is to be as reasonable as possible, though politics is essentially unreasonable. The art of politics is to make the unreasonable look reasonable.
Necessarily. Politics can be very reasonable also.
3, will a group within the legislature party asserting their separate identity and acting dehorse the political party or contrary to its directions have per se incurred disqualification under paragraph 2? Then 4, can a group within the legislature party asserting their separate identity and acting dehorse the political party or contrary to its directions have the constitutional authority to alter the leadership of the political party in the House or the whip appointed by the political party in the House? Directly in issue. Because of those documents, Malas, I've shown to your lordships already that you are removed from Assam, you are removed as the chief whip, and I continue to be the party and you are removed as leader. I continue to be the group leader. 5, given that an elected government should be allowed to serve its full term, this is now a constitutional premise, Malas, on the basis of which I made this proposition. Given that an elected government should be allowed to serve its full term as a matter of constitutional law, Can a group within the legislative party asserting a separate identity dislodge an elected government while proceedings for disqualification under the 10th schedule are pending, that is, before the Speaker decides on the issue of disqualification? Directly an issue. Well, what you're doing in this process is sidetracking the disqualification proceedings, toppling a government, and then saying, now my Speaker will decide. Actually, the constitutional premise and every constitutional authority should in fact help in ensuring that an elected government continues to be in power. Whereas something that I'm going to argue later, but I want to just tell your lordship something very interesting. Whereas a governor has to decide to administer the oath of office. So 30 people go to him, 20 people go to him. The governor must first know which party they belong to. Either it's a post-poll alliance or a pre-poll alliance, right? So the governor must first ask them, which is that party? Now, their position, 39 members' position is inchoate. They can't represent the Shivsena. This is the first time this issue has arisen in this country. So, how does the governor decide that I'll administer oath of office? There is no party before it. I'm just touching it, Mullahs. This is an issue that your lordships will have to consider. So, Mullahs, let's come to 6. Should the governor, who is constitutionally obliged to sustain the continuity of an elected government, change the status quo by allowing for a change in government before disqualification proceedings are decided by the Speaker? Then next, whether the governor can swear in as Chief Minister a person against whom a notice for disqualification has been issued by the Speaker acting as a tribunal under the 10th schedule and is pending adjudication. What is the impact of pending disqualification petitions on the ability of members to participate in a test of strength on the floor of the House when their vote would have the effect of toppling the government? I can understand in a situation, Mullahs, that really doesn't matter, the outcome would be the same. But here the hard facts are, their vote topples the government. So you have allegedly, according to me, a member who should be disqualified, voting to topple an elected government without the governor asking him which party you belong to. Without the governor, Mullahs, even finding out for himself. Or the governor saying, look, there are some disqualification petitions. By this, an elected government will be toppled. Let's stay our hands. We will not administer oath of office till the disqualification is decided. He can say that. Should he say that? Should he not say that? That's, Mullahs, an area where, Mullahs, your lordships have never looked at, so to say. Well, obviously, it's premised on constitutional morality. Then, Mullahs, can a constitutional court, in a matter relating to disqualification under the 10th schedule, decide the matter on its own without referring the matter to the Speaker for decision? And if so, under what circumstances? This is directly what my lord put to me, and we are aware of it. If the decision of the Speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Because it relates back, Mullahs, he is the Chief Minister. What do we do? Which is why the time is of the essence. What is the impact of removal of para 3 of the 10th schedule? I've already argued that. In what circumstances do the Speaker recognize the whip and the leader of the political party? I'm arguing that. What is the scope of powers of the Commission with respect to determination of a split? That's something I'll argue later. This is, Mullahs, according to me, the issues that your lordships might wish to look into. Now, Mullahs, kindly have a look at my overview document, which is, Mullahs, document for our submissions, petitioner submissions.
A.
A, that's correct. And kindly have a look at outline and over PDF page 5 overview. Well, as your lordships may skip that, I want your lordship straight away to take you to the issue of the whip. Chapter 7. Yes, of whips and the role of political parties.
Which portion?
This is that PDF page 70, Malak.
No, which file?
Of the written submissions of petitioner, but the same document.
Petitioner
A, written submissions A, Malak, of the petitioner. Page 70.
1 minute.
I hope to finish today, Malak, so that I don't take too much of your lordship's time.
Did you say it's PDF page?
Page 70.
70. 70.
70.
Sorry, 70. Yes.
Chapter 7. What is the scope and power of the Speaker to determine the whip and the leader of the House? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, the petitioner respectfully submits that the leadership of the original political party is exclusively empowered to determine which member of the House shall be the whip, and also the leader. Lordship, Justice Shah doesn't have it?
Yeah, now.
Petitioners respectfully submit that the leadership of the original political party is exclusively empowered to determine which member of the House shall be the whip, and also the leader of the House Legislature Party. The Speaker is bound to recognize the person who are communicated by the leadership of the original political party to be its whip and leader of the House Legislature Party. The Speaker's role in this regard is merely administrative in nature. The Speaker cannot abuse his role to defeat the spirit and intent behind the provisions of the 10th schedule. Now, it is submitted that the respondent's case is hinged on a legal misconception that the whip under paragraph 2(1)(b) of the 10th schedule can be issued, changed by a majority of the members of the legislative party, which is what they did on the 22nd of June. The defense is in the teeth of the plain reading of 2(1)(b), which my lord has already read, Malas. So, Malas, that's exactly what we were wanting to do. A bare reading of the aforesaid provision would show that the framers of the 10th schedule were conscious that the disqualification was to be incurred for violation of the whip issued by the political party or any person or authority authorized by the political party. There is no reference at all to the legislature party in para 2(1)(b) of the 10th schedule. This distinction between political party and legislative party is also borne out from a reading of paragraph 1(b) and 1(c) of the 10th schedule, which brings out the difference between the meaning ascribed to the legislative party and the original political party. The respondents in defense have sought to intermingle the definition of political party with that of the legislative party, and have sought to extrapolate the legislature party in the place of a political party in 2(1)(b). It is further submitted that para 1 of the 10th schedule makes a clear distinction between the term legislature party and original political party. The term legislature party is defined as the group consisting of all the members of that house for the time being belonging to that political party. And the term original political party is precisely defined as the political party to which a member belongs. Further, the definition makes it clear that the said term is specifically defined for the purposes of 2(1) of the 10th schedule. In this regard, Kuldeep Nayyar's case, you'll kindly have a look at paragraph formulas. Just the quote there. Authorities are certainly not wanting, which indicate that courts should interpret in a broad and generous spirit the document which contains the fundamental law of the land or the basic principles of government. Nevertheless, the rule of plain meaning or literal interpretation described in Maxwell's interpretation of statutes as the primary rule could not be altogether abandoned today in interpreting any document. Indeed, we find Lord Evershed, the length and detail of modern legislation has undoubtedly reinforced the claim of literal construction as the only safe rule. It may be that the great mass of modern legislation, a large part of which consists of statutory rules, make some departure from the literal rule of interpretation more easily justifiable today than it was in the past. But the next is very important. But the object of interpretation and of construction, which may be broader than interpretation, is to discover the intention of the lawmakers in every case. C. Crawford, the object can obviously be best achieved by first looking at the language and used in the relevant provisions. Other methods of extracting the meaning can be resorted to only if the language used is contradictory, ambiguous, or leads really to absurd results. This is an elementary and basic rule of interpretation as well as of construction processes, which from the point of view of principles applied, coalesce and converge towards the common purpose of both, which is to get at the real sense and meaning, so far as it may be reasonably possible to do this, or what is found there laid down. The provisions whose meaning is under consideration are therefore to be examined before applying any method of construction at all. And 2.1a and 2.1b makes it very clear. Violation of the whip and voluntarily giving up membership. And well, as your lordships with experience knows, what act amounts to voluntarily giving up membership? We endorse and reiterate the view taken in the above quoted paragraph in the judgment. It may be desirable to give a broad and generous construction to the constitutional provisions, but while doing so, I'll just read this, to the rule of plain meaning or literal interpretation, which remains the primary rule, has also to be kept in mind. In fact, the rule of literal construction is the safe rule unless language used is contradictory, ambiguous, or leads really to absurd results. I'll continue after lunch.
We'll come back after.
Yes.
The thing, you're not the only person who's feeling hot in the pot. We agree with you. We have to start the SCs.
Yes, Malaz, your lordship should, Malaz.
Mr. Maninder Singh, is it the heat of the weather or the heat of Mr. Kapil Sibal's arguments?
Both together.
Only light.
Malaz, this is the generosity of the bar, Malaz. That's all I can do.
We'll start the SCs.
Malaz, I was reading PDF 72. And Malaz, I was at the end of the paragraph. I was reading now para 174.
174.
Yeah, 174. At PDF page 72.
Yes.
It is submitted that Parliament in its wisdom had used the term political party under the provisions of 21B, wherein a member attracts the disqualification for going against the wishes or directions of its political party. The respondents in substance are asking this honorable court to read the term political party as legislature party, which has a completely different meaning altogether, as pointed out here and above. In this regard, it is well settled that when the language of a statute is amply clear, as also the words used are self-explanatory, the court ought not to read any other interpretation into the language of the statute. It is further submitted that the question whether the term political party under the provisions of 21B of the 10th schedule refers to the legislative party was considered by Justice Srinivasan in a separate opinion in Mayawati. Now let us kindly have a look at that, para 70. The argument of the appellant is the expression political party in subparagraph B means political party in the House. In other words, the legislature party. This argument runs counter to the definition contained in 1C. Your lordships will notice that 1C says original political party. 21A and 21B makes no distinction. So the political party relates back to 1C, therefore it's the original political party, so therefore it can't be the legislative party. That's what Smollett held. According to that definition, original political party in relation to a member of a house means the political party to which he belongs for the purposes of subparagraph 1 of para 2. The expression original political party is used in para 3 only. Para 2 does not at all use the expression original political party. The said expression in para 3 is equated to the expression political party in para 2.1. The definition clause in para 1C does not make any distinction between subpara A and subpara B of part 2. But the appellant's counsel wants us to make such a distinction. According to him, political party in subpara A would refer to the original political party, but the same expression in subpara B would refer only to the legislature party. The term legislature party having been defined in 1B, it would well have been used into 1B. Instead, the term political party, if the intention of Parliament was to refer only to the legislative party. There's another feature in 3B which negatives the appellant's argument. According to 3B, from the time of the split in the original political party, such as the one referred to in the first part of the para, the faction referred to therein shall be deemed to be the political party to which the member concerned belongs for the purposes of subparagraph 1 of para 2, and to be his original political party for the purposes of para 3. The entire subpara 1 of para 2 is referred to therein, meaning thereby both clauses A and B of subpara 1, and no distinction is made between the two clauses. Hence, for the purposes of clause A as well as clause B, the faction referred to in the first part of para 3 shall be deemed to be the political party mentioned in subpara, and the same faction shall be deemed to be the original political party mentioned in para 3. It is thus clear that political party in clause B of subpara 1 of part 2 is none other than the original political party mentioned in 3. The argument that the context in para 2.1b requires to equate political party with legislature party, even though the definition clause runs differently, is not acceptable. A reading of subparagraph B and the explanation of 2.1 places the matter beyond doubt that the political party in subpara B refers to the original political party only and not to the legislature party. According to the explanation, for the purpose of the entire subpara, an elected member of the House shall be deemed to belong to the political party, if any, by which he was set up as a candidate for election as such member. Certainly, the legislature party could not have set up the member concerned as a candidate for election. According to the learned counsel for the appellant, the legislature party may have to take decisions now. This is the argument. May have to take decisions on urgent matters in the House. And as it represents the original political party in the House, whatever direction is issued by the leader of such legislature party must be regarded as a direction issued by the political party. There is no merit in this contention. When the provision in the Constitution has taken care to make a distinction between the legislature party and the original political party, and prescribe that the direction should be one issued by the political party or any person or authority authorized in this behalf, there is no meaning in saying that whatever the leader of the legislature party directs must be regarded as that of the original political party. It squarely answers the argument. Their argument is, we are 38, we are therefore the political party. So 38 people in the Legislative Assembly as members can't be the political party. They are the legislative party, members of the legislative party. The reason is not far to seek. Disqualification of a member elected by the people is a very serious action. And before that extreme step is taken, it should be proved that he acted contrary to the direction issued by the party which set him up as a candidate for election. Then they go to Holohan. We don't have to go there. We've already, now I come to 176. Okay, my learned colleague points out just one part. Where middle of that paragraph, member is, I'm just seeing that. Yes, it says, the said object would be achieved if the disqualification incurred on the ground of voting or abstaining from voting by a member is confined to cases where a change of government is likely to be brought about or is prevented, as the case may be, as a result of such voting or abstinence, or where such voting or abstinence is a matter which was a major policy and program on which the political party to which the member belongs went to the polls. For this purpose, direction given by the political party to a member belonging to it, the violation of which may entail disqualification thereto, would have to be limited to a vote on a motion of confidence and no confidence in the government, or where the motion under consideration relates to a matter which was an integral policy and program of the political party, on the basis of which it approached the election. Now let us kindly come to 176. It is humbly submitted that the interpretation sought by the respondents is accepted. If the interpretation sought by the suspected, the same would result in a far-reaching consequences and would destabilize the framework of the party system by taking away the powers assigned to a political party to prevent defections within. This reading would negate the meaning ascribed to 2(1)(b) of the 10th schedule, as well as defeat the entire purpose of insertion of the 10th schedule to curb the menace of defection. The entire edifice of our parliamentary democracy is based on a party system. A candidate is chosen by the electorate on the symbol of the political party. The legislature or the legislature party is only a product of the political party. My Lord, the Chief Justice just articulated that earlier. The legislature party is the species and the political party the genus. There is an umbilical cord which links the political party and the legislature party. The actions of that umbilical cord cannot be out of line with the objective of the political party. In Kyoto, this court said the following. Well, this is important. But a political party functions on the strength of shared beliefs. Its own political stability and social utility depends on such shared beliefs and concerted action of its members in furtherance of those commonly held principles. Any freedom of its members to vote as they please, independent of the political party's declared policies, will not only embarrass its public image and popularity, but also undermine public confidence in it, which in the ultimate analysis is the source of sustenance. Nay, indeed, its very survival. Intra-party debates are, of course, a different thing, but a public image of disparate stands by members of the same political party is not looked upon in political tradition as a desirable state of things. Loyalty to party is a norm being based on shared beliefs. A divided party is looked on with suspicion by the electorate It is natural for members to accept the opinion of their leaders and spokesmen on the wide variety of matters on which those members have no specialist knowledge. Generally, members will accept majority decisions in the party even when they disagree. It is understandable, therefore, that a member who rejects the party whip, even on a single occasion, will attract attention and more criticism than sympathy. To abstain from voting when required by party to vote is to suggest a degree of unreliability. To vote against party is disloyalty. To join with others in abstention or voting with the other side smacks of conspiracy. That's exactly what happened here. And it started on the 21st of June. Clause B of para 2(1) of the 10th schedule gives effect to the principle and sentiment by imposing a disqualification on a member who votes or abstains from voting contrary to any directions. The provisions, however, recognize two exceptions. One, when the member abstains from the political party prior permission to vote or abstain from voting, and the other, when the member has voted without obtaining such permission, but his action has been condoned by the political party. This provision itself accommodates the possibility that there may be occasions when a member may vote or abstain from voting contrary to the directions of the party belongs. This in itself again may provide a clue to the proper understanding and construction of the expression any direction in clause B of paragraph 2(1), whether really all directions or whips from the party entail the statutory consequence, and whether having regard to the extraordinary nature and sweep of the power, the very serious consequences that flow, including the extreme penalty of disqualification, the expression should be given a meaning confining its operation to the context indicated by the objects and purposes of the 10th schedule. We shall deal with this aspect separately. It is thus submitted that it is the political party which appoints the chief whip and not the legislative party. The political party is headed by the leadership, and this factum of leadership is not in dispute. Organizational elections in Shivsena were held on 27/2/2018. Well, that's a wrong date. Actually, it's 23rd January 2018. And the leadership structure of the party was intimated to ECI, wherein it is clearly stated that Uddhav Thackeray is the Paksh Pramukh. It may not be out of place that under the Maharashtra legislative members' removal of disqualification rules, which I've read.
already shown.
So, Malad, I'll skip that. The whips are the directions issued by the political party and not the members of the legislative party or the leaders of the legislature. Then Erskine May says whip serves as an intermediate between the leaders and parliamentary membership of their parties in order to keep each informed of the views of the other, which is what I was mentioning to your lordships. Made great efforts to bring their the phrase adopted by Burke caught public fancy and soon became popular. Then let us kindly come to 183, skip the 5-6 lines on top, and the sentence on the right side, they keep members supplied with information. They were talking about whips. Joseph has that. They keep members supplied with information about the business of the house. What happens traditionally is, the members do not know the business of the house because the business of the house is decided by what is called the Business Advisory Committee. And only some members of the House of political parties are members of that committee. So every week, couple of times, every week, a meeting takes place as to what should be the business for the next week. So that's decided, and then it is announced in the House. On that basis, the whip then informs the members of the House that this is going to be the business. These are the bills that are to be debated. This is the position that we have to take on the bills. Therefore, you please prepare your speeches in the context of the position of the party. That's the job of the whip. Now, it's not that. That is not the job of somebody who says, I am a group leader and I will decide. That is why the whip is appointed by the political party, for that very reason.
On general parliamentary business, how specific are the whips? I mean, this is not unrelated to this case. I mean,
Well, a WhatsApp message is sent to us. Three lines at the end. Underlining, otherwise you have to be present, otherwise action will be taken against you.
whip.
And you come and vote, and this is how you have to vote. A three-line whip will come. Vote for this bill, vote against this resolution. So each one under our WhatsApp, that message is sent. So we have to be present. They're very generous, because while we argue, our cases, proceedings are going on, so we're not present. So they don't trouble us too much.
Special exemption 9 schedule. Special 9 schedule.
that holds for Mr. Jetmanani also, right?
Well, my personal opinion, this is my personal, I don't want to say it. The fact of the matter is, if you want to practice, you should practice. You want to be in parliament, devote your time to parliament. That should be. Otherwise, we can only perform one function, we can't perform both. Anyway, that's another matter. No, it's not that. It's what happens is that the key issues of the party are nowadays before the court. And they want us to be here. And slowly, Mr. Jetmalani will realize as the burden increases that he might also have to do that.
Just once again, aside about coming out of the halls of parliament, a very leading left leader mentioned, was inside the house, that lawyers, chartered accountants, doctors, and other similar people should not be in parliament. They should concentrate on their profession. Mr. Jaitley and I were talking in the lobbies once. So when he came out, a good friend of ours, we told him that you want parliament only to consist of unemployed and unemployable persons.
Don't say that. Don't say that publicly.
This is what happened.
He
said it
statement.
generally for a lot of us. He says, I'm taking his example. He said it for a large class of professionals, not lawyers alone.
Yeah.
So well, there is a certain amount of input you bring in if you are otherwise also gainfully employed.
That's true. But lawyers in many jurisdictions are not allowed to do both things. That's also true, but that's neither here nor there. The keep members supplied with information about the business of the House and enforce party discipline, being constantly in touch with the members in the lobbies of the House, the whips acting as intermediaries between the leaders and the rank and file of their parties, keep the former in touch with the currents of opinion, not only within their own party, and thereby nip the incipient revolt in the bud, but also to some extent with other movements of opinion inside the House. And it is through the whips that members of a party come to know about their leaders' views and the plans into which the leader thinks it is necessary or expedient to initiate them. The whips are the active agents within the parties, a channel of communication whereby one party negotiates with another concerning topics of debate or conduct of business in the House. In the handbook of the working of the Ministry of Parliamentary Affairs, the background of origin of whips is noted in this regard. It is stated that whips who are drawn from various political parties are vital links in the internal organization of parties inside the legislature. The expression whips is derived from the, we don't have to go into that. Then Riley Kamal, the House of Commons Library, that also goes to Edmund Burke. We've already read that. Let's not waste our time on it. Then kindly see further, para 186. Further is elucidating the duties of the whip. It is stated as follows. The primary role of the chief whip is to get the government's business through parliament, and in particular to secure the government's majority in votes on its legislative and policy programs. The duties of the whip include keeping MPs and peers informed of forthcoming parliamentary business, as I told your lordships, maintaining the party's voting strength by ensuring members attend important debates and support their party in parliamentary divisions, and passing on to the party leadership the opinions of backbench members. The note also relies upon Roger and Walters. Let's leave that. Kindly come to the Law Commission. This is very important. Page 1, para 188. The Law Commission recognized the importance of the whip necessarily by abiding by the whip and observed in para 3.4.4 as follows. Necessity for abiding by the whip. In such a case, the endeavor should be to strengthen the political parties by providing for internal democracy and internal structures rather than to weaken them. Inasmuch as we are recommending in this report insertion of a new chapter governing the political parties, including the provisions ensuring internal democracy, internal structures and transparency in the conduct of affairs, there should be no objection to strengthening of the political parties so that the will of the majority prevails in a political party. Freedom of speech is undoubtedly precious, but when a person becomes a member of the political party, accepts its ticket, and fights and succeeds on that ticket, he renders himself subject to the discipline and control of the party. It should also be noticed that when a person applies for the ticket of a political party, he knows and expected to know about the leadership, internal working, policies and programs of the party. He must also reckon with the fact that in future, the leadership may change, policies and programs may change, and so on. If he, with his eyes open, applies for and obtains the ticket and contests and wins on that basis, he cannot plead later that he does not agree with the leadership or policies of the party. This is all this argument, that was made, freedom of expression, we have a right, we feel that your policies are wrong, you have deviated from ideology. You knew the ideology. You knew that he is the Paksh Pramukh. You knew what he stands for. You took his ticket. You were minister. You never raised your voice. And suddenly, in Assam, you go to say that, no, we are very, very concerned about it. Prior to 21st of June, where is a single statement that is on the record of this case? Not a single statement. That's because you got lured into it. That you thought that maybe by using your majority in the legislature, you could actually topple the government and become the chief minister. So then it says, well, any difference of opinion must be first ventilate and fight within the party. Kindly see that. Your Lordship asked me that question, then what does he do? He has to ventilate it within the party, call a meeting. Then, more important, the membership of the House does not become his private property, nor can he trade in it. How prescient, these words are. That's not his private property, nor can he trade in it. I mean, I'm sure, he wasn't in Assam for cleansing his conscience, There were bigger issues that were to be dealt with in Assam, somewhat akin to some ground issues. Anyway, it is a trust that he is in the members of a trustee. He cannot also say that he will take advantage of the name and facilities of a political party, fight the election on the ticket of that party and succeed, but he will not subject to the discipline of the political party. This is simply unthinkable, besides being unethical and immoral. He has to abide by the party discipline within the House. He might fight within the party to have his point of view or policies adopted by the party, but once the party takes a decision one way or the other and issues the whip, he shall have to abide by it or resign and go out. This, in essence, tells you, what the contours of the conduct of a member of the legislature in the House should be. And in what circumstances, and there are only two, that he can actually disobey the whip. One, he can take the permission of the leader, and two, he says something contrary to the whip and the party condones it. And this Law Commission report led to the 91st Constitutional Amendment, deleting paragraph 3. So in practice, the connection between the political party and its elected legislators is maintained by the office of the Chief Whip, who in his essence is the representative of the political party amongst legislators. Then Perumal versus that. Just kindly have a look at the paragraph 12, but I won't read the whole thing. The paragraph starting second paragraph, the whips have to know their men. Your Lordship has that paragraph?
Yes.
The whips have to know their men. This involves a close contact with all members and knowledge of their interests, special aptitudes, qualities, and potentialities. Whips take these aspects into account while sending list of speakers to the chair in the interest of quality of debate and deliberations. They keep members, no, I cannot go to the speaker. No member of the legislature can go to the speaker in parliament, or Rajya Sabha or Lok Sabha, that I want to speak. He has no choice in the matter. The party will decide who is the party, Malas. It's the leader. That on this issue, on cooperative societies, my member in the legislature knows more about cooperative societies than somebody else. Therefore, allow him to lead the debate. In finance, Malas, who leads the debate in Rajya Sabha? Mr. Chidambaram. Who decides that? The party. So, Malas, each person has his expertise on education, on telecom. There'll be different people in the House who will be espousing the cause of that subject matter because he has expertise. And who decides that? Not even the leader. Leader will put up the name to the party president or the UPA chairperson or the party. And then they will say, okay, now you let him decide, let him debate. So this whole argument and sitting in Assam, I can throw you out, I can throw the whip out, and I can change the leader of the House, and I'll proclaim myself to the leader of the House. What is the speaker going to do when you send it back to the speaker? And this realization dawned 2 years afterwards, Maharaj, when he was a minister and all that. So being constantly in touch with the members of lobbies of the House, the whips acting as intermediaries between the leaders and the rank and file of their parties, keep the former in touch with the current opinion, not only within their own party and thereby nip the incipient revolt in the bud, but also to some extent with other movements of opinion. And it is through the whips that members of a party come to know about their leader's views and the plans into which the leader thinks it necessary expedient to initiate them. The whips are the active agents within the parties, a channel of communication whereby one party negotiates, and I'll leave that out. Then, let's kindly come to the next paragraph, para 13. The chief whip is the eyes and ears of the leader of the party, so far as the members are concerned. He conveys the wishes of the leader to the members of the party and keeps the leader informed of the current opinion in the party, as also the moods and inclinations of individual members when these deserve special notices. During sessions in his capacity as advisor to the leader, he normally meets the Prime Minister not only on one set interview daily, but also several times in the course of the day for brief consultations. Why, Malas? What happens is there is hangama in the House. People are going to go to the well. You immediately have a meeting with the leader. What should we do? Because the House is adjourned for 15 minutes, 20 minutes, half an hour. You go back to the leader, you have a quiet meeting with us. The whip will have a quiet meeting. A decision will be taken, conveyed to the legislature. So to say, Malas, that I am 40 members of the legislative party, I can do what I like, I'm a separate group, I'm a separate entity, I can remove you, it's unthinkable in parliamentary democracy. Unthinkable. And Malas, this per se, that's why I use the expression per se, is voluntarily given up membership of the party, per se. Apart from making the House and keeping essentials for transaction of business, the chief whip has the whip hand in shaping the course, tone, and tenor of debate on special occasions, for he selects the speakers from his party and hands over a list to the speaker for facilitating the process of catching his eyes. The responsibility of keeping everybody at his post and keeping his party united, strong, and well-knit falls on him. He selects members for the select committees and other parliamentary and government assignments, keeping in view the background, experience, aptitude, qualifications of members of his party. This gives him, supposing a select committee is to be formed and a person to be nominated. Who decides that? If 40 members of the House will say, no, because we are 40, we nominate this person? No. The whip will tell the speaker that this is our nominee on this select committee or this joint committee or the standing committee. So this gives him wide power of patronage, which comes handy in keeping with party members amenable to his influence. It is thus clear from a reading of the aforesaid that the whip forms an important link, an umbilical cord between the political party and the legislators. The whip enforces the directions of the political party. Then, my lords, there is a discussion about how the term political party as well as actually was not there in the constitution earlier, or not constitution, even otherwise was not there in a statute. Then was 29A of the representation. I don't have to go through the history, Mullahs. We are short of time, and I don't want to, Mullahs, take time unnecessarily. My learned friend can, if he wishes to deal with some of this. Then, Mullahs, kindly come to. Yeah. Well, there is a judgment of this court in 2018, volume 9, SCC, 2018-9 SEC, page 100. This is Sailesh Manubhai Parmar versus Election Commission of India. Yes. Mullahs, in this case, Mullahs, they wanted to introduce nota option in the Rajya Sabha elections, Mullahs, for elections to the Rajya Sabha. Mullahs, in that context, Mullahs, at page 116, the judgment starts at 100. I just read one paragraph, paragraph 19 at page 116. Page 116, paragraph 19.
Yes, we all are.
Yes, no, I'll just read it. The aforesaid passages throw immense light on the distinction between direct and indirect elections, and especially on the concept of indirect election, which encompasses proportional representation. There is voting by open ballot, and it has been so introduced to sustain the foundational values of party discipline and to avoid any kind of cross-voting, thereby ensuring purity in the election process. They have been treated as core values of democracy and fair election. It is worth to note that in a voting for members of the Council of States, the nature of voting by an elector is a grave concern. It is because if in such an election, there is a party whip, and the elector is bound to obey the command of the party. The party discipline in this kind of election is of extreme significance. For that is the fulcrum of the existence of political party. It is essential in a parliamentary democracy. The thought of cross-voting and corruption is obnoxious in such a voting. In this context, we may refer with profit to the then para, Mullahs, 22 at page 118. 23, actually. No, let's deal with 20. So we have to cut out this thing. Time is short. 23 at page 118. If I may read, Mullahs. In a democracy, the purity of election is categorically imperative. The democratic body politics, as has been held in Manoj Narula, stipulates that the quintessential idea of democracy is abhorrent to corruption and law's emphasis on prevalence of genuine orderliness, positive propriety, dedicated discipline, and sanguine sanctity by constant affirmance of constitutional morality, which is the pillar stone of good governance. The purity of democracy does not withstand anything that has the potential to create an incurable chasm in the backbone of a democratic setup. The law is meant to eradicate the same. When one analyzes the exercise of choice nota in the voting process of the Council of States, where open ballot is permissible and secrecy of voting has no room, and further where this discipline of the political parties matters, it is clear that such choice will have a negative impact. That's all, Mullahs, that I wish to state. The Mullahs coming back to So I skip that. And I come, Malas, now to, I have dealt with the facts now, Malas. And no, I don't want to take too much time now. Then, Malas, now I come to the governor's decision.
Chapter 9.
Yes, Malas, chapter 9. I'm not going to intra-party decisions, Malas. I'll just save time. Come to chapter 9. Now, Malas, this is, as I said, an issue that has arisen for the first time. A member of the BJP, along with...
Where does chapter 9 begin? Page 100?
No, sorry, page 100.
Page 100.
I'm sorry. I should have mentioned that.
Yes.
Well, that's 235. It is respectfully submitted that the exercise...
Is the 8th of June decision of the governor,
Sorry?
which is, it's the 28th of June decision of the governor. Decision of the governor, which,
To invite Shinde, Malas.
that's right,
Yeah.
28th of June,
30th.
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 Both, because there are
28th is our trust vote. We do not, Malas, go to the trust vote.
30th.
30th, Malas, he's sworn in.
Correct.
Correct. Now, Malas, your Lordship knows that under the Constitution, there are areas where the governor has discretionary powers, subject to 3 exceptions which are given in Nabum Rebia. This is an area when, in the beginning, Malas, there's an election that takes place. Who is to form the government? There is enough discretion with the governor. He will see as to whether there's a pre-poll alliance, and if the pre-poll alliance has majority, he'll call the leader in the normally. I mean, there are exceptions. There's a if he doesn't get a pre-poll alliance majority, he'll call a post-poll alliance. And if not, Malas, he'll otherwise see if a majority can be cobbled up by a leader who has the confidence of the House, who may have the confidence of the House. That discretion is always with him, Malas. Now, Malas, we are talking of the discretion of a governor post the formation of a government. That's the first issue. So, post the formation of an elected government, if 10 people go to the governor, what is his discretion in the matter? Because the governor has to ascertain, one, that look, these people along with others, the leadership that I will administer the oath to will have the confidence of the House. That's one, Malas, one criteria on the basis of which he'll swear in him. 2, Malas, he will ask the question, which party do you belong to? He's naturally have to ask, Malas. I am sure he will know that before even he asks that question. So he knows, Malas, that the Shivsena is not before him. On the 30th, he knows Shivsena is not before him. So what is his discretion in administering the oath of office to Eknath Shinde? Except the fact that all the 39 rebels will support, all the BJP, along with the 39 rebels, will oust the government and will support the new chief minister. He also knows, Malas, there is a disqualification petition pending. So your lordships will have to decide for the first time, in situations of this nature, when there's already an elected government in place, and there is a taint, alleged taint, of a certain set of members pursuant to the fact that disqualification proceedings are pending, whether the governor can exercise discretion in a manner which will topple an elected government, not await the outcome of the disqualification proceedings. The governor could have done 2 things. Could have said, I know for a fact that there is a disqualification notice against you all, or against 16 of you. You who want me to administer an oath of office to want to be the Chief Minister. The court has given you time till the 12th of July. Please first file your reply on the 12th of July, see the outcome of those proceedings, and if there is no taint as far as your membership is concerned, I will administer the oath of office to you. That, I think, is a constitutionally moral path that the governor ought to have adopted. Because institutional morality demands that he follows that path. The Constitution, in fact, persuades him to follow that path. Why? Because there's an elected government in place, of which he was a member. He himself. Eknath Shinde was a member. So why would a governor administer oath except that he himself knows that the elected government will be toppled? That's a very serious matter, according to me, Malaj. You looked at the Sarkaria Commission report, Malaj, your lordships will find no such eventuality, Malaj, considered. The governor, which
Eventualities are to be considered on experience.
That's true. That's true. Because ultimately, democracy only thrives when institutions uphold the sanctity of the Constitution. And quite frankly, Manas, and this is again my personal opinion, no court, no institution should balk from that, should withhold its hands from that. Because ultimately it's the message sent by court, by institutions, that we are above the vicissitudes of fortune that come with politics. That's the only way, Manas, to gain respect within the public and to uphold the values for which our forefathers gave us this republic. But unfortunately, that's not to be. So, Manas, here there is a big conundrum, very big conundrum. So first, Manas, the 27th order, the 29th order, then the governor. Even the governor could have stopped it. When he even chose not to stop it. So your lordships will have to evolve some principle in the context of, because this, if Nabam Malaj is not overruled, this will happen time and again. And the governor will play, I'm sorry to say, Malaj, I've seen the governor, it happened in Arunachal. Played ball. And we have seen, Malaj, and I mean no disrespect to the institution of the governor, we have seen governors performing a more proactive role as institutional heads within the state, which has created disturbances within the polity. So, therefore, how your lordships will evolve a principle to ensure that constitutional morality is upheld is something that I leave it to your lordships. I cannot give an answer. I can only say in the facts and circumstances of this case, the governor should not have administered the oath of office to Eknath Shinde because he was not the leader of the Shivsena. There was a pending disqualification petition against him. He belonged to the Shivsena, but had dissociated himself with the Shivsena. And he had no locus. Who was to go to supposing whether the Shivsena was to form a government with the BJP, who was to go to the governor? The leader of the Shivsena. That's the Paksh Pramukh, Uday Uddhav Thackeray. It is he who would represent the Shivsena before the governor and say, okay, we want to join hands with the BJP. In what capacity was Eknath Shinde before the governor? In which capacity? And in which capacity did the governor accept or give him audience and administer the oath of office? And let us kindly see, Shinde has never disputed that because he says, I am the Shiv Sena, and he has never disputed that Uddhav Thackeray is the Paksh Pramukh. He is not disputed even today. So in what capacity did he go to the governor? Where did he get his authority from? Not from Uddhav Thackeray, not from the Paksh Pramukh.
Yes.
In fact, Maharaj, what the governor does in this process, it revives the concept of a split and allows it to be alive before him, even though para 3 has been deleted. Gives it legitimacy. Now, all this is violation of 2(1)(a). All this per se, Maharaj. What is the speaker to decide? From the 21st of June, right up to 30th of June when he's sworn in, each act amounts to voluntarily giving up membership of the party. Each act. And under the 10th schedule, he has no defense because there's no amalgamation. May I, Malaj? Your Lordship, my Lord, the Chief Justice asked me a very pertinent question, Malaj, as to what a person should do if he's unhappy. Malaj, and actually the answer lies in a judgment of the Election Commission, Brahmanand Reddy, which was, Malaj, came up in SLP to Supreme Court. SLP was dismissed. But it's, I just give it to my
That's
Lord.
the judgment of which court? That's the judgment of?
Of Malaj, the Election Commission.
Election Commission.
Yes. Just give it to my Lord, please. Malaj, when you proclaim that you continue to be member of the Shiv Sena, you also proclaim that you are working under the constitution of the Shiv Sena. Naturally, Malaj, you must assume that. And the constitution of the Shiv Sena allows you to voice your opinions in the form of a dissent or otherwise, and to get support from primary members of the party or from the Pratinidhi Sabha, as well as the Karyakarani, so that you can actually articulate your concerns. And so it is in this context, Malats, this order was passed by the election commission, and this judgment, Malats, I want my lord's attention to what paragraph? What have you given? Yes, it is here. Which 72, Malats. Yes. Malas had a couple of questions for me.
There are just two things. Much of the submissions, I don't know whether they will join issue with you.
Yes.
Straightforward from the interpretation of the constitution and the provision. Two aspects, one relating to the leadership issue, which is staring in the face of the speaker at least. That is one aspect of the matter. How does one deal with it?
Other is?
That's what is staring in the face of the speaker.
Yes.
Leadership issue.
Yes.
Particularly in the context of the legislators.
Correct.
Now, another aspect I want your exposition on that is that legislators double up as the political leaders in every district.
Yes.
They are the same legislator.
Yes, yes.
Here he is a legislator. In a district, he is a leader.
Yes.
And normally we all know that in the district, the legislators are the top leaders.
Correct.
Invariably.
Correct.
An MLA in a district is not.
Correct.
So therefore, he wears the hat of a political leader. And he comes into the legislative assembly and he is a legislator there.
Yes.
So therefore, he in a way represents the political perspective also.
Sure.
While he is performing the function of a legislator.
Sure, sure.
So therefore, the question arises as to how, whether there's some kind of an overlap with respect to the position of a legislator as a person representing the political part of the political party.
Yes.
At what stage and what is the test to determine it? Sadiq Ali is in a different context. But of course, substantially, what you have told us that the batting order or for the speaker is first to determine the 10th schedule issue. But in the context of these two factors, I just wanted your...
Well, what happens is, I tell your lordships, I represent a particular assembly constituency in a state. The nature of that constituency may be entirely different from the nature of another constituency 100 miles away. The nature of issues may be entirely different, Mullahs. As your lordship knows, Mullahs, the spread of the other backward classes and constituencies are different in different states, different in one state also. The nature of the population, the SC/ST may be more, SC may be less, backward may be more. Mullahs are highly complex issues. But when you come to the legislature, you're not looking at your constituency. You're looking at the issues of the state and the politics of the state in the context of including the nature of the problems that you may face in your constituency. So, Mullahs, in fact, the interests of the legislature, when it comes to the interests of the state, are subjugated. The interest of his district or his particular parliamentary constituency is subjugated to the larger interests of the state. That's why it's the whip who decides what should be done, what should not be done. But you are right, there is an element of interplay, Mullahs. But he can't, on the context of that element in his own interest, his constituency, say that I will not obey the whip of the party. That's the nature of the animal, Mullahs. And therefore, Mullahs, he has to do that. As far as the speaker is concerned, Mullahs, the speaker has no choice in the matter. Speaker has only conveyed what the party conveys to him. Speaker has no individual right to say you are the whip or you are, I now proclaim you to be the whip. That can't.
Here there is no overt act in the nature of the legislators calling the members of the party to have a prior meeting, and thereafter the legislators themselves...
Even that can be done. Well, according to even that can be. Supposing all of them said, and the party whip said otherwise.
You are saying that the legislators can sit together and take a decision?
Yes, Mullahs, because they will have to obey the party.
No. Can the legislators sit together and say that now we are the party?
No, they can't. They can't. Well, then there's only merger, Mullahs. Then. That's the only difference is paragraph 4, Mullahs. That can't be. Well, this is the conundrum, Mullahs. This is a conundrum which was
But these same legislators don't sit in the parliament, but go out and call for a meeting.
Of the political party, yes.
As a political party.
Only, yes, they can.
As if it's under the banner of a political
That they can't do, Mullahs. That they can't do.
But then if they are the majority?
No. They are majority in the legislature, Mullahs. Yes, they are the majority in the legislature, there's no doubt about that. But they can't call a meeting of the political party because they're bound by the
You'll
constitution
have to
of the
slightly
party.
also explain to us how in Sadiq Ali they got over this problem. Just
Well,
explain to us.
Sadiq Ali, I'll tell you Lordship straight away. Sadiq Ali, it's Congress J and Congress O. And the court said in Sadiq Ali that both Congress J, both in the organizational wing as well as in the legislature, in parliament, have a majority. So there's no issue at all.
Then that Kerala money.
Both. Both you have to see. The organizational wing as well as the not one.
Was additional. So
That's correct. That's correct. Correct.
there were.
That's right. So that's what they
And also identical in that, I don't know what that name in Kerala, that money, what is that?
Unni
Interest
Krishnan.
money.
Unni Krishnan.
No, some other-
Money.
Some matter.
Kerala Congress. I'll find out. We'll find out.
Recent
But Mullah, the
decision of Kerala High Court.
question is, they are bound by the constitution. There's a constitutional procedure given by the party constitution through which they can articulate their opinions, which is exactly what Brahmanand says. This is why I was reading it.
Let's take.
Precisely the point. Paragraph, page 12, Mullah, at the bottom. Now, about 10th line from the bottom, to take a view that the commission, page 83 of the compilation. My Lord, the Chief Justice also asked me that question. I'm trying to answer that. Page 83, Malads, about 10th line from the bottom of that paragraph, to take a view that the commission, Lordship has that?
Sorry, space.
Difficult.
Sorry. I was just thinking. Okay.
You can mail it to the court master. They will mail it to us.
There was some problem in email going to the court, therefore I could not.
Yes, even the airdrop is not coming. You see.
Some signal issue.
Which paragraph?
Para, Malads, 83, 10th line from the bottom, to take a view that the commission, while deciding cases falling under paragraph 15. My Lord said that? Well, as your Lordship knows, paragraph 15 says when factions have arisen pursuant to a split in the political party. (72) at 83, Malad. My Lord, the Chief Justice has that?
Yes.
To take a view that the Commission, while deciding cases falling under paragraph 15 of the Symbols Order, should not be concerned with the party constitution, would be to introduce utter chaos in the functioning of the political parties in the country, and the operation of the Symbols Order would be rendered a plaything between the various shades of opinion or groups in the political party. It cannot be gainsaid that a group claiming to be a particular party must abide by its own constitution,
Yes.
which imposes contractual obligation on its members unless it is shown that a clear impasse had been reached where the functioning of the party could not be carried out in accordance with its own constitution. To ensure a healthy standard of political life, the Commission should not lay down any procedure which will make it easy for the established political parties to break up at the slightest pretext. The Commission considers that a group or section which wants to form a rival group within a party must declare itself a rival group and assert that there has been a split in the party. It must show that it has exhausted all the remedies available to it under the constitution of the party to assert its majority, but that the other group has frustrated its efforts whimsically or capriciously and is not itself function in accordance with the provisions of the constitution of the party or democratic norms. The rival group must also show that it has no alternative but to come to the Commission to establish its majority in the party. So the answer, Malas, to the question is, you have to, under the constitution, go to the party. Make all efforts. Raise your voice, articulate your opinion. Get a membership of a substantial number of members of the party. They may not be a majority, even minority of the party with you. Claim then that there is a split in the party. attempt to change the leadership. You can't do that. If you can muster up majority, Mulaj, you will become the party. If you can't muster up majority, Mulaj, then you say there's a split in the party. Then the election commission will decide who gets the symbol. And that also from a future date, Mulaj. Now, Mulaj, the question here, unfortunately, is there is no meeting of any party. Meeting is in party in legislatures in Assam. What is the political party and the members of the political party in Maharashtra have anything to do with the meeting legislators in Assam, Mulaj? And it's not even their claim. So you don't call a party meeting. You have not called it prior to 21st of June. Mulaj, what's very interesting is that in Sadiq Ali, that's a principle that your lordships must keep in mind. The court said that I will not go into the actions that have taken place after there has been a dissonance between two factions, because each section has thrown out people in the other section and vice versa. I will take the position prior to that. That is, what was the state of the party prior to that? In this case, prior to 21st June? There's nothing prior to 21st June. There is no split. There is no attempt to split. There is no talk of split. So, Mulaj, how does paragraph 15 come in? Paragraph 15 comes in only when there are two factions pursuant to a split. There is no case of a split. The case of a split happens, Mulaj, on the 18th of July, according to the petition before the Election Commission. We are dealing with disqualification on 21st of June. And 18th of July, there is no meeting of the party. There is no notice, there is no venue, there is no time, there is no evidence of any meeting. Because if there is a meeting of the party, notices must also come to us, because we happen to be the party. No notice even to their own people is shown. So, Mulaj, the question of paragraph 15 also doesn't arise. That we'll argue at 3:30, but this is the problem. So you don't go by the Constitution. You don't claim to have a split. You say the legislative party or 30 of them, 38 of them are the political party. And then, Mulaj, you go with the BJP and get yourself anointed as the Chief Minister of the state. Now, I'll quickly go through, Mulaj, what I have said so that finish it. I'm at para 235, Mulaj. It is respectfully submitted that the exercise of discretion by the governor in inviting a person to form the government must be in accordance with constitutional provisions and values. While democracy and rule by majority is part of the constitutional scheme, the prohibition on defection is equally a constitutional mandate. Hence, while according respect to the principle of rule by majority as envisaged in a democracy, the governor must have regard to the constitutional prohibition on defection. Consequently, the governor is duty-bound to refuse to recognize a majority that has been secured through unconstitutional means. The scope of judicial review of the exercise of discretion by governor would necessarily extend to ensuring that the discretion was not exercised in a manner that disregarded the constitutional methods of securing the right to govern. But that decision of the governor is justiciable. All decisions of the governor are justiciable. So whether he could have administered an oath of office or not, in the context of the facts before you, is a matter that is to be decided by your lordships. And if that decision goes, everything goes. Admittedly, in the facts of the present case, there was no merger as envisaged under paragraph 4 of the 10th schedule. These rebel MLAs have not merged in any other political party or formed a new political party. Therefore, even if it is assumed that 2/3 strength of legislature party, para 4, is not at all attractive. The president of the Shivsena, Uddhav, had publicly and admittedly not aligned, supported the BJP. In these circumstances, the satisfaction of the governor for the purposes of calling upon respondent number 4 to be chief minister, as the head of 39 rebel MLAs of Shivsena, which is not endorsed by the Shivsena political party, is by itself ex facie unconstitutional. The Constitution prohibits recognition of rebel MLAs of a political party under the 10th schedule, and the action of the governor legitimizes what is expressly prohibited by the Constitution. The governor has sought to recognize what the Constitution prohibits. The governor is also not empowered under law to recognize who is the Shivsena. Who is the governor to say that? That is the domain of the Election Commission. Admittedly, recognition of the Shivsena and its leadership by Uddhav Thackeray has been endorsed by the Election Commission, and there is no dispute whatsoever or challenge before the appropriate authority as on 30th of June. In these circumstances, the governor in his ipsit dixit, guided by his political masters, acted mala fide, legally mala fide, I don't mean any other way, mala fide, and in the teeth of the provisions of the Constitution, granted de facto recognition to the 39 rebel MLAs by inviting respondent 4 to be the chief minister. It is submitted, Mullahs. I'll finish it tomorrow now. To not more than 10-15 minutes. I'm done, Mullahs.
Come back. We'll resume tomorrow morning.
Yes.
And we'll come back now for the next.
Yes, Mullahs. Let's be obliged.